Dr. O? Morning. Dr. O?
Hello? Hello?
Morning,
Yeah, we can hear
morning,
you.
Doc.
I'm all right, and you?
I'm fine, Doc. Can you hear us clearly from the venue?
Yes, I can hear you clearly.
Okay. As mentioned yesterday, you will not be able to see the evidence leader and the chairperson unless you have a device separate that will be on live stream. But on this Zoom session, we are the only ones that can see you, but you can't see the chairperson or the evidence leader.
Okay.
But-
All right.
but-
I'm worried to get another device and then have live streaming because
Yes.
then I'm
Yes,
I'm going to look like some IT wizard and going between screens.
Yeah.
Unless it is
No,
and I'm also worried about there might be an echo.
Yes, but we are hearing you very clearly, and if you're hearing us very clearly, then that should not be a problem.
Okay, all right. Yeah.
Okay, thank you so much.
Yeah, okay.
We'll be starting.
Can I make another request? Sorry?
Yes, ma'am.
Hello?
Yes, ma'am.
Can you just, if you could please, and it's just a request, advise the evidence leader as well as the DCJ, because I don't think they might not realize that I cannot see them. So I noticed yesterday that sometimes the DCJ and I would be talking at the same time because I didn't know that she was maybe just taking a pause because I can't see. So if you can just advise that I cannot see. So if there are
Yes,
visual cues,
Okay, ma'am, thank you so
I
much.
will not see them.
Yes, they are aware of
Thank
that, ma'am.
you.
Thank you so much, yes. But the
Okay.
sound is clear,
Thank
which is
you.
important. The DCJ can see you, and your sound is very clear, which is nice and clean.
Okay, thank
Okay.
you.
Thank you so much, Doc. Thank you.
All right, sure.
Ucela ngene ba.
Dr. Ndata? Dr. Ndata, we're about to start. Are you there? Thank you so much, ma'am.
Yes,
Thank
sir.
you. Thank you.
All rise.
Good morning, Mr. Slager. Good morning, everybody.
Morning.
Are you ready?
We are ready, Chairperson.
Okay, let's start.
Thank you.
Dr. Nteta, good morning to you.
Good morning, sir.
The oath you took yesterday continues to apply today. You understand that?
Yes, I understand that.
Okay, all right.
Thank you, Chairperson.
Proceed.
Yes. Chairperson, Dr. Nteta was giving her apology from yesterday. She can't see us, but we can see her. So she's unable to see whether we have stopped talking. So sometimes there was an overlap between us talking and her talking.
Oh, why is that?
I don't know, Chair. I don't know why. It's
Well, the
not possible.
technicians, have you asked the technicians?
I've asked the Reverend.
Why is that? Because we have never had that situation. Let the Reverend tell you what's going on.
Chair, the Reverend says the witnesses can only see you if they have the laptop in front of you. But once they've disconnected your laptop, then the witnesses can't see you.
They can only see me if what?
If a laptop for you is connected to the meeting link,
And why is it not connected? Because it's always connected on other occasions.
yeah. Yeah. Should we address it at tea time, Chairperson? What the Reverend is explaining is the laptop was once there, and on the Chairperson's request, it was removed, but it could probably be connected somewhere else, I don't know.
Yeah, no, I'm going to adjourn and to get this sorted out. What should have been done, what should not have happened, is that it should not have been removed without me being told that its removal would have this effect. Nobody said if it was removed, this would be the consequence. And if I had been told that that is what would happen, I would have said it should be kept. So nobody said this is what would happen. How long can it take for it to be connected? Because I don't like this idea that the witness can't see us.
Yes. He's indicating about 10 minutes, Chair.
Yeah, we are going to adjourn. That must be sorted out quickly so that we can then continue.
Thank you, Chair.
We adjourn.
should I mute?
Yeah, you're welcome to mute in the
Thank you.
meantime. Yes.
Hello,
Good morning, Dr. Ndeta.
morning.
Yes, can you see me?
I cannot see you. I can see a computer screen with headphones on it. And on that computer screen, I then can see the room. It's being, the computer screen is being lifted.
Okay, yeah, we're trying to sort that out. David, your two guys at the van must put this position. There we go. Can you see the screen, ma'am?
I see the computer screen, yes.
Yes, that's what is going to happen.
Okay.
David, ask your van guys to cue this camera.
Hello? Oh, there's another Ayanda. Okay. I can see a gentleman on a green chair with a cell phone on.
Yes, that's the chairperson's chair, ma'am. That's what you're going to see. I'm the acting chairperson at the moment. That's where the chairperson will be seated. David,
Okay.
David, can you ask the guys to just test with the evidence leader as well, so that we can see? Essie, can you please speak from your mic?
Yes, 1, 2, 3. Testing, mic 1, 2, 3.
Can you see the evidence leader, ma'am?
Yes, I can. There's a glare behind him. I don't see him well, but I can see his silhouette.
Okay, ma'am, that's fine. At least if you can see the chairperson and the evidence leader, which is much better now.
No, she
Okay.
can't see.
Okay, ma'am, thank you so much. David, are we ready?
Yeah, that's better.
Dr. Ndeta, at some point, you'll be able to
Yes.
see yourself as we go along. Please don't be alarmed. It's how the technicians have sorted that out.
Okay, no problem. I did see myself at some
Oh,
point.
yes, when you speak, you'll see yourself, yes.
Okay, all right, that's fine.
Okay. Solihle, you're the one must move. Are we ready now, David?
I'm assuming you can hear me, so thank you very much, everybody. It does make it a bit easier for me.
Oh, okay, ma'am, that's fine. We'll just finally touch up and then we'll be ready. Can you see the chairperson's chair now, the green chair?
Yes, I can.
Okay, thank you. And the evidence leader?
No, now I'm seeing like glare of a screen on a screen.
There's the
Now I
evidence
see
leader.
him.
Okay, that's
Yes.
fine. Thank you so much.
As I said, he's not very clear
We'll sort that out.
because
ma'am.
there's a glare behind him.
Don't worry, we're trying to sort that out quickly. Yeah, that's fine. Thank you. Colleagues, 5, 4, 3, 2, 1, ready? Thank you. That's fine. That's okay. Yeah. Tembani. It's fine. It's okay. To me. Don't worry about the level, as long as you can see the chairperson. To me. To me. Ready. Thank you.
starting.
Can Dr. Nteta see us now?
She can see us, Chair.
Dr. Nteta, can you see me?
Yes, I can see you.
And the evidence leader, you can see him as well?
I think I will see him now I can see him.
Or
Yes.
when he speaks?
Yes.
Okay, all right. Now, Reverend Stumela, is this light the way it should be? Okay. You're putting me in the dark, in darkness. I think maybe he's not happy that I said they must make sure the witness sees us. So he's retaliating by putting me in darkness.
There's vengeance.
Okay, all right. Okay, all right. Let's proceed then.
Thank you, Chairperson. Dr. Nteta, yesterday we were about to go into your second meeting with Mr. Tony Gupta.
I'm sorry, Mr. Seleka, before we proceed,
Yes, Chair.
can we have a common understanding of how much time you need to finish with her evidence?
Oh, yes.
What's your assessment?
Let me see, Chair.
I think yesterday you may have gone to just before half of her statement, I'm not sure.
Yes.
So
Yes.
I was wondering, I was having in mind that you might need 1.5 hours or so, or at most 2 hours.
Let's try 2 hours, Chairperson.
Yeah.
Let's try
Okay,
2
but
hours.
I think just up the pace as you ask questions,
Yes.
so that we try and get as much done as possible within the time.
Thank you, Chair.
Okay, all right.
Yes, Dr. Nteta, we're about to go into your second meeting with Mr. Tony Gupta. Just before I do that, just one thing I need to clear with you, and that's going back to the reasons why you left ESCOM. We have seen from Mr. Jabu Mabuza, the former, was it a chairperson or a CEO of ESCOM? Chairperson in 2018?
Chairperson.
Yes. That his evidence was to the effect that you resigned while there was a disciplinary action pending against you. Could you comment on that quickly?
Okay. And I will take the liberty of relating from the beginning of my affidavit. And I indicated in my affidavit that I had mainly 2 reasons for leaving ESCOM. The first reason was to continue with my studies. And the second reason was really because I felt that the incoming board and executives at the time, I felt, and it is my opinion, that the continued undue interest in various transactions within the primary energy space, this trend was going to continue. So having been requested to provide a submission for a transaction, another transaction, which was adjudicated in the evening of a Friday, and some other discussions that I did have with some executives, I felt that I wanted to leave ESCOM because I did not want to continue to endure what was unpleasant. And at the time, my direct line manager was the CFO. I had a conversation with the CFO in March of that year, indicating to the CFO that I would like to exit my employment at ESCOM. And it was indicating what my notice period would be and wanting to have a cordial discussion with him, of which we did, in terms of when would I like to leave. He asked me when am I thinking about leaving, etc. If I'm elaborating too much, you will interrupt me. So.
Okay.
So at that point, I said to him, well, I will then come through with a letter of resignation at the end of the month, but I didn't want to have a discussion with him prior to that. It was around about the middle of the month. I was later, probably the next week, I think it was, I was then called in by the group executive for generation. At this point, I want to note that I did not report to the group executive for generation.
I'm sorry,
and
I'm
they
sorry,
then
Dr.
handed
Nteta.
me.
I'm sorry, Dr. Nteta. Just tell us who the CFO was. You have just told us you had a discussion with the CFO. Tell us who he or she was.
Mr. Kasim.
Mr.
Kasim. What is?
Is it Caleb Kasim? Kalib
Yeah.
Kasim.
Mr.
Caleb, sorry, Caleb Kasim.
Mr. Kalib Kasim.
Yes, I think his name is Kasim, but Caleb.
Okay, all right. Okay, continue. It's just important as you talk about positions to tell us who was occupying that position at that time. So
It was Caleb.
Yeah,
Yes.
okay, all right, continue.
Okay. It was Caleb. I then had later when I was called in by the acting group executive in generation, which was Mr. Willie Majola. And for a meeting, I entered the meeting and he had somebody from labor, from HR there. And at that point, they handed me a suspension letter. I indicated to Mr. Majola that I have, in the previous weeks, had a discussion with my immediate manager, indicating that I did want to resign. And I then asked the HR person as well, so what would be the process going forward with this? At the time, they seemed surprised, I must say. And then they said, well, we are giving you this and you are asked to vacate the premises with immediate effect. Of which I did. I vacated the premises with immediate effect. So that is the letter of suspension. Having done that, I then wrote to, a few days later, I think it was, I wrote to my immediate manager, which is Mr. Caleb, the CFO, and I indicated to him that, our discussion, and I then indicated to him that I've subsequently from his colleague received a letter of suspension. However, in light of our discussion that we had, I would like to still continue the process in terms of serving my notice, even though I was asked to leave with immediate effect from the suspension. And that is that letter is actually is documented, and I'm sure they have it. I can provide a copy. And so I then served my notice in terms of the ESCOM. It was a month's notice that I was required to do. I think probably 2 weeks in that notice, they indicated to me that they would be scheduling, I think it was a disciplinary. Once again, that was not coming from my immediate manager, it was coming from his colleague. And my limited understanding of HR is that it is your immediate manager who disciplines you and not colleagues within the organization. And then I received documentation from my manager in terms of resignation, the normal documentation, and they engaged with me, HR engaged with me. And then I had my last day at ESCOM at 30th of April 2018.
Yeah. So,
The reasons for the suspension, sorry?
So, one, you had a discussion with your immediate manager where you indicated that you intended resigning, and before you could submit your letter of resignation, you were served with a suspension letter. Is that sequence correct?
Yes. I had agreed with my manager. Sorry, sir.
After you had been served with a letter of suspension, you immediately left ESCOM to comply with the suspension letter. Is that correct?
Correct.
How long after you had received your suspension letter did you submit your letter of resignation? About a week?
I'm going to say probably about a week.
Yeah, more or
so.
less, more or less. Okay.
More or less, yeah.
Yeah, okay, all right. And then they told you about scheduling a disciplinary hearing, but that never happened because then your resignation took effect. Is that correct?
Yes, so during that, the period of my notice, about 2-3 weeks into that, they sent me the letter.
Yes. And was the disciplinary hearing scheduled for a date within your notice period or outside of the notice period?
They didn't give a date.
Or as yet?
It was more, yeah, they didn't give a date or a venue. In fact, I think it was more of just stating what the
charges.
issues are, because after the 4-day suspension, they need to then tell you, what
the charges are.
what the charges are.
Oh,
So
they were
so let
telling
me
you
rather
what
say it was more like charges.
They were telling you what the charges were going to be.
Yes.
Okay, all right. But then your resignation took effect before there could be a hearing.
Yes, before they came back to me.
Yes. You said you served your notice. Does that mean that you came back and actually worked, or you served your notice on suspension?
I served my notice on suspension. I came in at the end of my notice at the request of the then chairman to attend to some in the other investigations that were ongoing, to provide evidence for that.
Okay, all right. Mr. Selega?
So yeah.
Okay, Mr. Selega?
did those investigations pertain to your conduct? Where you were called in to give aid?
Which ones?
The ones you say you were called in to give?
No, it was to do with, it was actually, some of it was Tegeta related matters, but it was to do coal contracts, not specifically my
Your conduct?
conduct.
I see.
Yeah.
Okay. Did the charges against you, if you can recall, did they relate to the Tegeta transaction?
So the charge is correct. They related to the Tegeta transaction. It was quite specifically related to, in my role as a senior general manager, primary energy, there was a temporary relief that I provided to Optimum Stroke Tegeta for coal coming through. And it was relief in terms of the qualities, for a set period. So that is what they were. And then they indicated that there's a breakdown of trust.
Yeah. I saw that you deal with that in your affidavit, the temporary reliefs that have been given to Tegeta?
Yes, yes.
Did they indicate what the factual basis was of the allegation that there was a breakdown of trust? In other words, did they say
So,
there's a breakdown of trust because you did A, B, C, D, E, and that's why there's a breakdown of trust? Did they indicate that?
So they indicated that there was a breakdown of trust based on the providing of the temporary relief.
So that was the sole basis, as you understood it?
Yes, as I recall, I'm actually trying to see if I can find the actual letter because I'm feeling that I may have
You might have
forgotten
not recall
something.
everything.
But yes, I might not recollect fully, but it was based on the temporary relief, and what I do recall is that they also indicated a breakdown of trust.
Yes, okay, well, if Mr. Selege have got the letter somewhere in their bundles, or he indicates they don't have. Okay, all right, so if and when you have found it, you will let us know. In the meantime, you may continue, Mr. Selege.
Thank you, Chair.
Sorry, Advocate Seleka, if I may just interrupt you.
Yes.
Do you want me to look for it now and send it during my time with you, or do you want me to get it later? I can get it at tea time if there's going to be
Maybe
tea.
she can get it through during a break or something.
I think so. Too.
How much time
Not
do you
a
think you
problem.
need to get it, or you are not sure?
No, I have it. It's just looking on my computer, but I don't want to do that while
Yes, that's
providing
fine.
evidence.
Okay,
Yeah.
okay, we'll do it.
So it won't
maybe-
take long.
We'll
I don't
do it during
anticipate.
some break.
Yes.
Okay,
Thank you,
let's continue.
Thank you, Chair. The aspect, Ms. Dr. Nteta, regarding the temporary relief afforded to Tegeta, it's of importance to some extent in regard to the Tegeta issues. And maybe you could explain to the chairperson briefly on this temporary relief. What does it entail? Because you say it related to, or as I understand it, it related to the quality and the quantity, which is the volume of coal. Correct?
Yes. So with regards to the temporary relief, the temporary relief that I signed was to do with coal quality and in terms of the volumes. So and which are operational issues. So the temporary relief that I signed is firstly based on a previous temporary relief that was provided to them, and it was for a limited period. What tends to happen in terms of mining operations is that as you're mining through certain areas, you might get to an area where you would experience what they would call a dike or some aspects that affect the quality and the volumes that you are able to provide through. So what we allow for our suppliers is that in that particular aspect, they would advise us that due to technical issues, we're not able to provide you with the volumes, and sometimes volumes and quality, sometimes it's both, etc. And then we will then say for that period, whilst you're mining through that dike, then you can then provide us with either a reduced quantities if it's affecting your operations, or we would then look in terms of the qualities if they would be we will still be able to use them. You can then reduce that quality. It's normally one particular aspect of the quality or two. They mine through that particular area. Once they've mined through that particular area, then they would then revert back to the contractual volumes and qualities, etc. Okay. So that relief was for 3 months to allow them to address their operation issues that they have, which is what we do for, it's just how we would manage contracts because of the robustness of mining operations.
Yes, no, that's all right, because what I'm trying to understand from you in regard to the relief is not so much the reasons, but what the relief entails. So that relief, if I understand you correctly, when you give a relief in respect of quality, that means you will then accept as ESCOM quality, coal that does not meet the required quality.
Yes. So, and why we call it it's relief in terms of that particular quality.
Yeah.
Or the volume as well.
Or the
It can be
volume.
sometimes the volume.
Yeah, so if
Yes.
they are supposed to provide, by way of example, 10,000 tons of coal is it per month or per week? You would compromise that and say, okay, I will accept 5,000 volumes of coal. Is that what the relief means?
Yes.
Yeah.
Yes, the type of relief.
Yeah.
Just raise
For a
your
period.
Just raise your voice,
Right.
Mr. Selega.
Thank you, Chair. And for the purposes of this aspect, you deal with that in your affidavit on page 69. Chairperson, that's ESCOM Bundle 14.
Just before that, Dr. Nteta, when you grant the kind of relief that you are talking about to a service provider, is the effect of the relief you grant to them, namely, is it that you condone what would otherwise have been a breach of the contract?
Yes.
So you effectively say, for the reasons that you have given us, we understand that you are going to provide us with coal that doesn't meet the contractual standards, either in terms of quality or in terms of volumes or both, for this following period, and we accept that. That's the effect of the relief.
Correct.
Okay, all right.
Yes. Thank you, Chair. So, insofar as quality is concerned, Dr. Nteta, we understand that these coal contracts have penalties, clauses in them, that if you fail to provide coal of a specific quality, penalties will be imposed. Correct?
Correct.
In this case, I referred you to the page number, page 69 of ESCOM Bundle 14, Chairperson, paragraph 7.4. Or we can actually start at 7.3. You are there, Dr. Nteta? Or you are moving?
Yes, I am.
Today. So that paragraph 7.3 says, during April 2016, the ownership of OCM changed from Glencoe to Tegeta as per sale of shares agreement. So April 2016. Subsequent to the cooperation agreement being signed, ESCOM issued a temporary relief agreement to OCM on 20 December 2016 for the period of 1 September 2016 until 31 July 2017. So that relief on 20 December 2016 is in fact issued to Tegeta as the new owner of the mine.
Yes. Yes, I don't know who it was issued to, but yes.
Yeah, because Tegeta is not, well, if you read that with your paragraph 7.3, because ownership changes hands, you say April, and Glencoe is no longer the owner, Tegeta is the owner. and on 20 December 2016, only Tigeta would be the owner at the stage. Did you issue that relief?
So the first relief I did not issue. The first relief, I think, was, so the relief that you're referring to in this statement, I did not issue.
Yes, okay.
It was issued by my predecessor.
Okay. Now, I'm taking you down.
I'm sorry.
Yes.
Did you say there is a first relief that you did not issue? You issued a later one?
Yes, so the relief that Advocate Selega is referring to in this paragraph 7.4
Yeah.
is a relief that I did not issue. It was issued by my predecessor.
And who was your predecessor?
That relief was issued by Mr. Edwin Mabilani.
Oh, okay.
Yes, Chair, see annexure
Yes, okay.
AKL08, AKLN08, which is on page 187.
Please speak up, Mr. Selega.
That's annexure AKLN08, which is on page 187.
Yes, okay.
Yeah. Indeed, it's a relief issued by Mr. Edwin Mabelane, but he's the Chief Procurement Officer at the time, Dr. Nteta, 20 December 2016.
Yes, at some point within ESCOM, Mr. Mabilani played the role of both Chief Procurement Officer and Senior General Manager for Primary Energy. So it's possible that during that period, he had both portfolios.
Yeah. And then there were subsequent reliefs granted to Tigeta, you say, further in your affidavit.
Yes, that's the one that I'm referring to that is linked to the suspension.
Just tell me this temporary relief that you granted and that Mr. Edwin Malibane also granted. The power to grant that relief, was it contained in the coal agreement or was it provided for in some other instrument within ESCOM? What was the source of that power?
So the power, and I'm going to give you my interpretation of it. The power to grant that relief lies in the coal operations, as it is an operational issue that we would have to look at and look at in terms of the merits.
Am I correct to understand you to say, as far as you know, it was not in the coal agreement?
So in terms of the coal agreement, that particular agreement is linked to mine. I would understand that would be part of the coal agreement in terms of coal management, the contract management, and contract management, which is indicated in the agreement, would then deal with issues of operations and how do you manage it. Because the department within primary energy that is called coal operations is delegated to manage, and they would look at issues of volumes within the contract, moving them up, down, if there are issues in terms of ramping up qualities, etc., as part of their function.
Okay, let's take this step by step. Are you saying that your understanding was that the coal agreement gave that power to those to whom the responsibility to manage the contract was given? Is that what you are saying? That
Correct.
was your understanding?
Correct.
In other words, you are saying the power to manage the contract, you understood to include the power to grant this kind of relief.
Correct.
Yes. Is there anything else other than the contract that you understood to be the source of this power, or is it only the contract?
It would be the contract. It would also be the delegations that are granted to the contracts management department.
Yes. And those delegations, did you understand them to have an express provision that talks about temporary relief, or not necessarily anything express, but you understood them to include the power to grant this relief?
I understood it that they would be, understood it as such, sir, that those powers that are delegated relate to being able to provide a temporary relief.
But would I be correct in understanding you to say, you are not saying if we go to the delegation, we will find an express wording that said you could, you had this power, but there might be no express wording, but your understanding was nevertheless that it was part of what was delegated, the power delegated in terms of delegations?
So my understanding is that the delegation that is provided to primary energy is to, one is to negotiate and conclude contracts, as well as to manage the execution of those contracts, which includes quality, price, and elements like that. So that is my understanding of the delegation provided to primary energy.
Other than the granting this temporary relief to Tegeta on this occasion, had you had other occasions where you granted this type of relief to another supplier or other suppliers?
Myself personally, no, but within the primary energy division, we would, so noting at the time that I was now the Senior General Manager for Primary Energy, which oversaw various departments. Before I used to only look in terms of on the sourcing side of things. So I would not have been involved with that personally before. However, within the coal operations department, they on a daily basis would manage and look in terms of those particular aspects. So I was aware that that is their role. Hence the motivation to provide this temporary relief came from the coal operations department.
So is the position that even though you might not yourself have had other occasions where you granted this type of relief to a supplier, you were aware that this type of relief had been granted to other suppliers by the relevant authorities within ESCOM in the past?
Yes, I understood it as the practice. Yes, not myself personally, but correct.
Yeah, okay. Mr. Siliga?
Yes, thank you, Chair. And that obviously will be surprising if you were to be charged for doing something that is the practice at ESCOM.
Correct.
So then ESCOM seems to have had a different view about whether or not you were authorized to do or offer the temporary relief.
Correct, which is why they would have charged me.
Yeah.
Did you understand the basis of the charges against you, or the charge against you, to be the mere fact that you granted the relief, or did you understand the basis of the charge against you or charges against you not to be the principle of granting relief, but the circumstances under which you granted the relief, that maybe as far as ESCOM was concerned, you granted relief in circumstances where you knew it should not be granted? Which one of these two was your understanding of the basis of the charge?
Okay. My understanding, and I did not get any engagement, if I can put it that way, with my principals on it. So I'm reading, my understanding is based on the letter that I received. My understanding is that ESCOM believed that I did not have the delegation to grant that relief.
Okay, all right. But as far as you are concerned, obviously you reflected on the charge and you have had time to think about it. As far as you are concerned, you did have the delegation.
As far as I'm concerned, I did have the delegation. It had been done before. There was a cooperation agreement with Glencore for 3 years based on the same principles, which was signed by my predecessors as well.
Yes, okay, all right. Mr. Selega.
Thank you, Chair. Dr. Nteta, you do refer to a cooperation agreement in paragraph 7.4 of the affidavit. You say,
Yes.
you actually also refer to it in paragraph 7.2, the cooperation agreement with OCM. But the cooperation agreement of 2014 was terminated by Mr. Brown Molefe after his secondment to ESCOM in May or June 2015. You are aware of that?
Yes.
Yeah. Now, after that, there was no cooperation agreement between ESCOM and Optimum. So which cooperation?
Yes.
Sorry. Which cooperation agreement are you referring to in paragraph 7.2? 7.4, I beg your pardon.
So the cooperation agreement in 7.4 would be the first temporary, no, the cooperation agreement is the one that you are referring to in terms of the one that was terminated by Mr. Molefe.
Oh, so is it my understanding that you thought that it was still the same agreement in place in 2016?
No, if I may.
Yes.
So my thought process at the time and in also providing this affidavit was to provide I refer to the cooperation agreement because in that cooperation agreement that was terminated by Mr. Molefe,
Yes.
It spoke to issues of quality and it spoke to issues of volumes as well, where there was a relief provided in terms of that agreement for those two aspects, right? So when I was then providing this particular narrative, I was referring to it based on the reasons or the information that is in that agreement. The temporary relief, the first one is the one that was signed by Mr. Mabelani, which was for, I think it's 6 months or so. I stand to be correct, more than that. I stand to be corrected. So that is a second document that I'm referring to. And then there's a third one, the one for which I did sign.
Yes, okay. So what I was just saying to you is, by this time, there is no cooperation agreement between ESCOM and Tigeta that we are aware of. So what you see is a temporary relief.
Correct.
Yeah, sorry. I should give you a chance to respond, yes. What we however see on the 20th of December 2016, when
I'm sorry, Mr. Selega, I'm sorry to interrupt you.
Yes.
You did earlier on mention on which page I will find this annexure AKL N08. I want to go there as you ask those questions.
page 187.
Is it 187?
Yes, Chair.
Okay, all right, then you may continue. I'm sorry I interrupted you.
Not a problem, Chair. So what we see then, Dr. Nteta, on 20 December 2016, is the temporary relief being granted to Tigeta. On paragraph 7.4, and the temporary relief applies retrospectively from the 1st of September. You see that?
Correct?
Yes. So this. So it will apply retrospectively to over 4 months before it is issued. And then it applies from December, January to July 2017 going forward. So that's adding 7 months into it. Because
Correct.
it ends on the 31st of July 2017. So that's more than 6 months.
Correct, I did say approximately, yes.
It's in 2017 alone it's 7 months. In 2016 alone it's 5 months. 4 or 5 months. So that's what, some 10 months there. But I want to ask you this in relation to this, because, well, it doesn't end there because you also give the temporary relief on the next page. You give it on the 18th of August 2017. You give it for the period 1
Correct.
August. Thank you. You give it for the period 1 August 2017. This is now immediately after the 31st of July 2017. 1 August 2017 to 31st October 2017. Correct?
Correct,
Now let's try to understand this. I heard you mention that the motivation for temporary relief would come from the Coal Operations Department.
correct,
So there's the Coal Operations Department of ESCOM.
correct.
Would the supplier itself make an approach to ESCOM to ask for temporary relief?
Correct,
And they would give reasons for that request.
correct,
And in this case, you were also given reasons in order for you to grant temporary relief.
from our core operations department, yes.
Okay, so you didn't receive the reasons directly from the supplier.
No, I received them from the coal operations.
So
Did coal operations say we received a request from the supplier for temporary relief or for the extension of the existing temporary relief? And these are the reasons they have given. We support their request for the reasons that they give, or here are our reasons for supporting the request. Did they say anything along those lines?
So, yes. So the coal operations department at ESCOM manages the coal contracts. So they on a daily basis engage with the supplier in terms of the running of the operations. So they would receive the request from the supplier. They would also have been, they would understand the operations of the mine, because their job is to manage in terms of those particular elements. So it would have been an engagement from them. They then provided me a memo supporting, as you've indicated, sir, the reasons for the temporary relief extension.
Okay. Mr. Selega?
Thank you, Chair. So the picture that emerges is like this, and you can comment on this. After Tegeta took over Optimum Mine, which is around April 2016, as you say in the affidavit, Tegeta, a couple of months later, is granted temporary relief with effect from the 1st of September 2016. The temporary relief applies to the quality of coal and the volume of coal, correct?
Yes?
That applied for 10 months until 31st July 2017. It's a period of 10 months from 1 September to 31 July. Immediately thereafter, you also issued a temporary relief for 3 months, from 1 August 2017 to October 2017. In total, it's 13 months. In October, and we know from the evidence that in February 2018, Tegeta goes into business rescue. February 2018. You know that?
Yes, February 2018.
Yes.
Okay.
Mr. Selega, on what page do I find Dr. Nteta's temporary relief to Tegeta?
It's the next page, Chairperson.
After the earlier other one?
Yes, correct, 188,
Oh, okay, thank you.
the next page.
You may continue.
Thank you, Chair. So that business rescue Tegeta goes into after the temporary relief is 3 months thereafter, 3 months after the temporary relief.
Well, before you proceed, Mr. Selega, can I ask this question, Dr. Nteta?
Yes.
I see that your letter to Mr. George van der Merwe, COO of Optimum Coal Holdings, where you granted the temporary relief, just like the one that had been done by Mr. Edwin Mabelane previously. Although it allows Tegeta to deviate from its contractual obligations, there seems nothing said on both occasions about how the price of the coal would be affected by this, insofar as, for example, quality is concerned. I would imagine that if you are going to give me grade A of coal, I'm going to pay a price that's appropriate for grade A. If you are now going to give me grade B of terms of quality, I can't be paying you for grade A. But I don't see anything in the letters that deals with that. Was that dealt with elsewhere, or is there some explanation for why there seems to be nothing dealing with it?
Okay. If I may be allowed an indulgence to talk a little bit about the contract. The contract, as it was quite an old contract, was signed, it was made on a rand per ton basis for coal within a certain coal quality. So the contract then talks to, if, for example, you do not meet your obligations in terms of a certain range, a certain volume, etc., then that's when it then begins to affect the price. So, and I'm going to provide the narrative to also try and answer Mr. Advocate Silika. Apologies. So that the temporary relief, which you talk to in terms of is a 10 months period, the issues that they had in terms of the mine continued from even the temporary relief, the cooperation agreement, which in fact was a temporary relief signed previously, so which was for 3 years. So those issues continued. Now, the temporary relief that I then granted to them spoke to the volume and the qualities for a prescribed period. However, they needed to ensure that they have done certain things. At the end of that period of the temporary relief, which I think it was around about October, in November, I then instructed the department to institute the penalties because they did not meet for the terms that I had for those 3 months, their obligation. They did not meet those obligations. So in November of 2017, we then instituted the penalties, and that resulted in us actually receiving coal for them for free. So from November, and then they ceased to supply because they indicated that they are unable to supply us anymore. And that is then also what then led to them, I would say, going into business rescue. So the financial aspects were then attended to within those mechanisms, and that is what allowed me to be able to institute those penalties.
Okay, I take it that your answer means that as a matter of principle, you accept that if they were going to provide coal of a lower quality, that should affect the price. But you are saying that although in the letter you did not address that, you say there was a mechanism in terms of which it could be addressed. Is that correct?
Within the overall contract.
Yes. But
so the contract had penalties, etc.
Yes. But the idea of temporary relief, is it not in the idea of enforcing penalties for the provision to ESCOM of coal that has been supplied, of coal of a lower quality, for example, that has been supplied to ESCOM during a period where ESCOM has provided temporary relief to the supplier? That notion seems to be inconsistent with the nature of temporary relief. You remember earlier on I asked you whether granting temporary relief effectively meant you were condoning a breach or breaches of the contract, and you said yes. You remember that?
Yes.
Yes. So what I'm raising is that the idea that ESCOM could later on impose penalties on a supplier for supplying coal that is of a lower quality than the coal provided for in the coal agreement seems to me to be inconsistent with the whole notion of granting temporary relief. Because as I understand your evidence, granting temporary relief is actually giving permission to the supplier to act in breach of the agreement because of the reasons given by the supplier, which you as ESCOM found to be sound. You understand what I mean?
Yes, sir.
So what do you say to the proposition that when you grant temporary relief, you can't be at the same time contemplating that you will impose penalties on the supplier later on for providing you with coal of a lower quality than that specified in the agreement? It can't be. You can't be contemplating both.
Yes, sir.
You accept?
I accept, and I will agree with you that in terms of our negotiations with suppliers, they agree with your sentiment that you cannot allow me, you cannot say that I can provide you with a relief in some form, and then later on, then you then penalize me.
Yes.
Now, the rationale, and I will speak from ESCOM's perspective, most of the times when we provide temporary relief, not most of the time, but a lot of the times, it's for the quality and for the volume. The quality, it is and I'm going to say this, and ESCOM will have to deal with the suppliers coming to them, in the sense that, so the quality that reduction that they have, in essence, is acceptable to us, to ESCOM. It's within a range that has the potential to be acceptable. Whether it means that we move it to another power station or the boilers can then be adjusted to receive that coal. Because one of the big issues that we have is the security of coal supply, we would rather say that we will receive the quality that we can burn for a period. But we do want the volumes. So oftentimes when we provide you with the supplier with a temporary relief, it will say that for this period, and because we look in monthly volumes, instead of providing us with 10,000 tons, you can provide us with 8,000 tons. However, on the end of relief, you must go back to your volumes that you require. The contracts also allow us to catch up those volumes. So sometimes we can then say at the end of that, give us more volumes. And that is because we are looking to secure the volume of the coal. So in your analysis, you're correct that the suppliers do feel that you can't say it is fine and then you later want the coal, but we need to secure coal.
You see, as far as you or ESCOM may provide temporary relief in respect of volumes, I don't have any problem about that as far as the price is concerned, because I take it that you will only pay for 8,000 if they 8,000 tons of coal. If they provide 8,000, you won't pay for 10,000. But when it comes to the quality, where you grant temporary relief in regard to quality, that's where my concern is. Namely, in terms of the coal agreement, you would have imposed an obligation on Tegeta to supply coal of grade A quality, and maybe for a certain period they did that, and your obligation is to pay a price that is appropriate for grade A quality of coal. after some months, they say to you, please grant us some temporary relief. We can't grant you grade A coal for the next 10 months for the following reasons, which you as ESCOM find acceptable. And I'm saying that when you then grant a relief to say they can give you grade B, you should be saying we will adjust the price as well. We can't be paying you for grade A coal for the next 10 months when you will be providing us with grade B coal. That's what I'm raising, because I don't see it addressed in the letter. I would have expected it to be addressed. Why was it not addressed?
It is not addressed because it is addressed in the overall of the contract. And when you talk about an A-grade coal is a band. So when we put in, if, for example, if a supplier came and said, we normally give you A-grade coal, which is a band from a CV, I'm just going to give an example of 26 CV to 30 CV, if I give that an example. The grade B is maybe a 25 CV. Jumping between a band is significant, but within the band, it is acceptable because we are able to adjust in terms of our operations. And the implication is smaller. So we would then accept it. The contract then addresses those various mechanisms in terms of how we would accept this particular coal to come through. I also gave an example is that there are various aspects that when you look at the coal quality. So you might have an issue of sulfur that we say that we will accept, ESCOM says they will accept up to 1%. And the supplier then says, can you provide us with temporary relief on the quality of the sulfur for 1.1 or 1.2? And we've looked at in terms of the significance, and then we would make a decision in terms of that. So it is not as clear to be able to then say X, and we try and cater for it within the contracts.
Are you saying the letter might not deal with that, namely the adjustment of the price, but the contract would have had a provision, or did have a provision, that effectively said, if the supplier provides coal of a lower quality than grade A, then this is how the price will be adjusted. Is that what you are saying?
Yes, so the contracts in general would do that. And also as we've moved further, a lot of the contracts are now based on a rand per gigajoule, which talks to the energy content. So the later contracts that I was involved in, then we would then, it talks to that particular mechanism.
And this particular contract, do you remember whether it had a provision for the adjustment of the price in the event of the supplier providing coal of a lower quality?
So this particular contract, if my memory serves me correctly, has quite an extensive penalty calculation and regime that talks to elements in terms of the type of qualities, the kind of volumes, etc. And there are some calculations that are there.
Yes, but provisions relating to penalties would not apply, I would imagine, based on what you and I have discussed earlier on, namely, where you grant temporary relief to a supplier of coal, you can't at the same time be contemplating that you will impose penalties for against the supplier because during the period of the temporary relief, the supplier provided coal of a lower quality. You can't be contemplating that. So what I'm looking for is whether you are saying, if we go to the contract in this case, we will find provisions that say, in effect, where ESCOM provides temporary relief, this is how the price will be adjusted. Or where it says, in the case of the supplier providing coal that is of a lower quality than stipulated in the contract, this is how the price will be adjusted. That is now separate from the penalties, because the penalties won't apply if you grant temporary relief. Are we going to find a provision that says that, as far as you remember?
As far as I remember, the contract doesn't talk about the issues of temporary relief, but it would talk to the issues in terms of how you manage the contract. I do want to say that I don't want to start delving into the details of this particular contract because I have not looked at it recently. But my understanding would be that it would then deal in terms of the mechanisms of it. Of the management of it.
Yes. Well, part of the reason why...
Yes, sir.
Part of the reason why one is looking at some of these things is because there is an allegation that before the change of ownership, ESCOM was very hard on OCM. They, for a long time, were complaining that they were operating under a contract that brought a lot of hardship on them and wanted ESCOM to accommodate their situation in various ways, and ESCOM, after Mr. Brown Molefe had arrived, took a very hard line against them. But once there was a change of ownership and Tegeta was involved, the attitude, ESCOM's attitude was very favorable to them. There was inconsistency if you look at how Glencoe was treated and how Tegeta was treated. So that's part of the reason why we are looking at this. Here is a situation where Mr. Mabelane grants them temporary relief for 10 months or 11 months, I'm not sure, and then you also come and you grant them. And when I look at the letter, it doesn't say anything about adjusting the price. It seems on the face of it that although the quality of the coal is lowered that will be provided, the price remains the price for grade A coal. That's why I'm trying to establish. But I think from what you have said, it seems that one, you accept that the letter granting them relief, both your one and Mr. Mabelane's one, doesn't deal with that. That's point one. Point two, I think you also say, as far as you can recall, and you have said that you would need to look at the agreement because you haven't looked at it recently, but as far as you can recall, the agreement did also not deal with the adjustment of the price during the period where temporary relief has been granted. It had provisions about penalties, and you and I agree that penalties can't be applicable for a situation where temporary relief has been granted. Is my summary of your evidence a fair summary?
Yes, I would like to add, if I may, sir.
Yes.
With regards to the allegations that Optimum had a difficult time prior to the new owners. I don't want to talk to that in the sense because I dealt with Optimum in terms of trying to look in terms of that particular agreement. I will, and I don't want to also deal with the temporary relief that was granted by Mr. Mabelani. I would rather provide my thinking behind the temporary relief that I provided to them. I provided to them a temporary relief of 3 months, and it was quite specific in terms of the period, because in my understanding is that if you are having difficulty with your operations and you have indicated to the operations team, ESCOM operations team, that it will take you the 3 to 4 months to resolve it, that then we are willing to look at that. But you will also note that of the different reliefs that were provided, my relief was linked to in November, where we then instituted, because in my opinion, you had been allowed 3 months to sort out your operations. You were not able to do so. So then we will then begin to institute and take, institute our penalties in terms of your agreement and actually not pay for anything that we get from you. And that was my thinking at the time. It did not mean that because it was now Tegeta, it was simply in terms of trying to get the coal, you're not able to supply us with the coal, we put in penalties, etc. They did complain that they felt it was unfair, but that was the contractual understanding and obligation that I believed served for my temporary relief.
Just to round off on this point, because one may be trying to look at this only to find that maybe the foundation of one's thinking is flawed. You would know whether or not the prices that ESCOM paid for coal were dictated, at least in part, maybe wholly, by the quality of the coal that would be supplied. In other words, I know we have been talking about different grades. Do you know whether there was that distinction, or was there no distinction about the, whether the quality was part of what was taken into account in saying we will pay so much for this coal? I would have imagined that
in the later years, the quality was linked to, the price was linked to the quality. And as we moved towards more of a rand per gigajoule contracting, so it was linked to the quality, it was also linked to the market.
Mm-hmm. So, and at the time of you granting this relief, does this fall within those years, or does it not fall within those years, the time when you granted the relief?
It was in the later years, however, the contract was linked to a rand per ton. So the
yes.
contract was signed, I think, in the 1960s. I stand to be corrected. Mm-hmm. So we were operating on an older pricing mechanism within a current period.
Yeah. Okay, Mr. Selega.
Thank you, Chairperson. Dr.
We have not gone on the tea break. We have gone past the tea break. We can take the tea break if somebody feels that they need a tea break. Otherwise, we could take it at 12 o'clock. Dr. Nteta, do you need a tea break right now, or comfort break? Or we can take the break at 12 from your side?
We can take the break at 12, sir.
Mr. Selega?
I'm also fine, Chairperson.
You're fine.
To continue.
Your junior is fine as well.
She
Okay,
takes
all
the
right.
cue from me.
Okay, let's continue. We'll take it at 12.
Thank you. Dr. Nteta, your explanation regarding your own temporary relief that you granted must of course be understood against the background of the previous temporary relief, which was given for 10 months. Isn't it?
Yes,
Because, in fact, in your affidavit, what you're saying is you were not giving them a new, well, the essence is you were not giving them a new temporary relief, you were extending the existing temporary relief.
correct.
So if it was an extension of a 10 months temporary relief, now you're adding 3 months to it, one wonders whether did you have different reasons at a time when you granted yours that were different from the reasons that were given to Mr. Mabelan 10 months before. I mean, in fact, in December 2016.
So one of the questions that I asked the coal operations team is that what has happened since December to up to this date? Were they not able to resolve their issues that they had, which was their operational issues and in terms of the area that they were mining? And the response that they provided is that they were not able to resolve those areas. They are still mining in that particular area. So there will still be issues in terms of the volume. Now, for those kind of engagements and understanding, I would rely on the people mandated to manage the contract to use their judgment and then say whether it works or not. So, and when you talk about in mining operations, it can take you 3 weeks to mine through an area, it can take you a year to mine through an area.
Yes, but...
So in them saying that it...
Sorry,
yes.
let me interrupt, because that's a general statement. One always has to confine oneself to this particular request, this particular relief that was granted,
Yes.
the reasons why it was granted, and why you signed for it, instead of making a generalized statement, because it doesn't assist us know the facts of what transpired here.
So specific to this agreement, I asked the coal operations department as to what has changed.
Yes.
Because they had the temporary relief, have they gone and mined through the area that they need to mine through? And the answer was that no, they have not. They still have challenges on their operations.
So the chairperson has accelerated the matter because it's exactly, I wanted to go exactly to where the chairperson was talking about. That, and I just need to make that statement for you, that prior to Tegeta taking over, the position of Eskom regarding Optimum, after they entered into that cooperation agreement, and they were also doing, as you quite correctly point out, it was a relief. It's a temporary relief in regard to the quality of coal and the volumes. However, when Mr. Molefe comes on board, he terminates that. And there's an insistence on the part of Mr. Molefe and Mr. Koko that we want the penalties to be paid of 2.17 billion. You're aware of that?
Yes.
And that is the stance that was adopted throughout until Optimum the mine is taken over by Tegeta. And now we see, after that, there's a different attitude on the part of Eskom. They are willing to compromise on the coal and the volume, the quality and the volume. And for a long period of time, 13 months, shortly before Tegeta is unable to operate and it goes into business rescue. You see the picture that emerges?
Yes.
Yes. So then, I'll move on. Well, just before I do that, the penalties that were imposed You say in November 2017. Were those the only penalties imposed?
Sorry, I didn't hear the question.
The penalties imposed in November 2017. Were those the only penalties imposed, to your knowledge, in regard to Tegeta?
I don't know. I'd request that you ask the finance department.
Okay.
As far as I know, it was the only ones, but I'm not sure.
Dr. Nteta, paragraph 2, number 2 of your letter granting temporary relief says that in effect, I think, ESCOM reserves its rights on all penalties and not dictate the same. What did that mean?
So, sorry, I can't get to that letter now, but
Page
so
188.
one of the elements in terms of reserving the rights is that though we are providing you with this temporary relief, we reserve the rights to impose our penalties we reserve our rights in terms of the contract so that we can then institute aspects of the contract, which is the clause that I used to then impose the penalties. I said that because we are reserving our rights.
But you remember what you and I got to understand each other on with regard
Yes.
to the place of penalties during a period of temporary relief. This gives one the impression that you, ESCOM, would be saying, we are granting you temporary relief, but we reserve the right to impose penalties on you for doing exactly what we have decided to condone. That doesn't seem to make sense to me, if that is what it means. Does it mean that, or does it mean something else?
That
In
is
other
my
words,
understanding, because it's an open.
Just to make sure you understand what I mean. When I read this, I understand ESCOM to be saying, we are granting you temporary relief, which means you can provide us less volumes of coal, you can provide us a lower quality of coal, and that conduct on your part would normally be a breach of the contract. And if you were acting in breach of the contract, we would be entitled to do a number of things, including penalties. Now we are granting you temporary relief. We are saying you may do those things, but at the same time, we are saying we are reserving our rights to impose penalties. Is my understanding of what it says correct?
It is correct, sir, which is why I said earlier that the suppliers would agree with you, because they say that you give us this opportunity, but you have something hanging over our head because you can come back and impose.
Are you saying, therefore, that although this is what is written here, you didn't really intend to do that because it wouldn't make sense to provide temporary relief and still impose penalties?
So the intention was to provide temporary relief, but we wanted to ensure that we reserve our rights. So if they, for whatever reason that comes out in that period, if something comes up, we want to be able to still institute and impose penalties. So it is a letter that is saying we understand your issues. However, we are keeping the door open for ourselves.
But did you accept that it doesn't make sense? The two can't live together during a period where you have granted temporary relief.
At the time, my thinking, whether it is flawed or not, was that we need to ensure that we leave the door open for ESCOM so that they can institute their penalties. So that was my thinking at the time.
Yes, but as you speak now, you can see the challenges with that.
Yes, I see the challenges
Yes.
for
Okay.
the supplier.
Okay, all right. Well, also for ESCOM, isn't it? Because you want to be genuine. If you grant temporary relief genuinely, you can't be, you can't grant with one hand and take away with the other. You accept that?
So you're asking a practitioner, a procurement practitioner. So I'll say I understand it, but I would also want to leave the door open for my company.
No.
So, yes, I hear you.
Yeah, but you understand now that although at that time that's how you thought, but when we interrogate it now, you can see where the challenges are with having that clause.
Yes.
Yeah, okay.
Thank you, Chair.
Mr. Selega?
Yeah. And, I mean, yeah, your penalties, the penalties imposed by you, Dr. Nteta, if it is you who imposed the penalties, it's for November.
Maybe, I'm sorry, Mr. Selega, just to make sure we round off on this, at least as far as my issue is concerned, Dr. Nteta. Do you accept, as you testify now, that where you have granted as ESCOM, where ESCOM had granted temporary relief to a supplier of coal, to in effect say, I'm allowing you to provide me with a lower quality coal for this period. ESCOM could not subsequently impose a penalty on a supplier for supplying ESCOM with a lower quality in terms of their own temporary relief. Do you accept that it could not do that?
Yes, sir.
Yes. So therefore, where ESCOM granted temporary relief, such as the temporary relief that you granted, and I know you said you didn't want to talk about Mr. Mabelane's temporary relief, but this would also apply to his. Then in that case where this temporary relief was granted, by implication, it meant that the supplier would not be visited with penalties for providing ESCOM with lower quality coal. You accept that?
Yes.
Okay, all right.
And in fact, Dr. Nteta, it was not for that period.
Pardon?
The supplier was in fact not visited with a penalties for the period of the temporary relief.
Yes. So we did the penalties, I think it was in November.
Yes, after that period, going forward.
For that month, yes.
Yes.
But the penalties that you're talking about, they did not relate, did they, to the period of temporary relief?
So I'd have to look in terms of the actual period, because one of the issues was the volumes, that they had to ensure that they provided a certain volume period. I don't recall the details in particular, but I think that they did not, but I'm not too sure. So it would be to look to those particular requirements in terms of that.
But I think you also said at some stage something to the effect that you imposed those penalties because they did not meet certain conditions that you had imposed for the temporary relief, is that correct?
Yeah, I would like to have a look in terms of the penalty that was imposed.
Yeah.
If my memory serves me correctly, there was issue, I think, of the volume. So that for 3-month period, and memory, I need to check, they didn't provide the minimum that they were requested to do.
So in other words, what you,
But I would really like to check that.
in other words, insofar as the penalties that you are talking about, that you sought to impose are concerned, you would be saying, we did not impose penalties in regard to conduct on the part of the supplier that we had condoned. We imposed penalties for conduct that we had not condoned. In other words, if they had said, we will provide 8,000 tons, and you had said, that's fine, you only imposed penalties when they provided less than 8,000. Is that correct?
I think, yes. Like I
that
said,
would
I
be your
would like to have a
understanding.
look in terms of that. Yeah.
But that would be your
Yes,
understanding?
yeah, I think so.
Yeah, okay, all right.
Yes,
Yes.
yeah.
In other words, they would have breached the relief that was even given. So they went lower than the relief that was even given, and for that they would have attracted penalties, insofar as they even breached the relief that was granted.
Yes, insofar as if they did breach that relief, yes.
So the principle, if your recollection is correct, would be, we won't impose penalties as long as you, the supplier, stay within the ambit of the temporary relief. But once you go outside of the ambit of the temporary relief, namely, we have agreed that you may give us 8,000 instead of 10,000, you then give us 6,000, then we will impose penalties because you are now outside of the relief we have granted. But as long as you stay within the four corners of the temporary relief we have given you, there will be no penalties. And as far as quality is concerned, if you continue to give us the quality that we have said is acceptable to us, for example, grade B instead of grade A, there will be no penalties. But if you then begin to give us grade C or grade D, then there will be penalties. Those would be the principles as you understand how you would have applied them.
Yes, and also within that period, we will almost like leave you, but as soon as that period is finished, then
Yes,
it's
you
a
go
different
back.
discussion.
Yeah, okay.
Chair, I want to go to a different topic. I see it's 3 minutes before 12.
Yes, okay. Let's take the tea break then.
Yes.
We take a 15 minutes tea break. We adjourn.
Thank you, Chair.
Dr. Nteta? Dr. Nteta?
Yes, I'm here.
Yes, we are going to resume soon.
Thank you.
All rise.
Let's continue. I see we were not able to keep within the 2 hours that we had agreed upon, but that's not your fault, Mr. Silega.
It's,
I had lots of questions for Dr. Nteta, which took some time.
it's not yet up, Chair. We still have some time.
Well, we started at 12:30, so the 2 hours will be up at 12:30. We started 10:30.
Yeah.
After the technical
The
issues that
technical
happened.
issue.
So I don't think you will finish within 15 minutes. But let's continue.
Yes.
The bottom line is that while we want to finish as soon as possible, we don't want to leave issues not dealt with properly. We seek to strike a balance between not being too slow and taking a lot of time, but at the same time, being able to do justice to the issues.
Yes.
Okay, all right.
Thank you, Chair. Dr. Nteta, I want to move on to a different aspect, which is your second meeting with Mr. Tony Gupta. Now, that's the meeting that comes after the contract with Tegeta in regard to Drakfontein has been concluded on the 10th of March 2015. You had the first meeting. Subsequent to that, you can't recall exactly when. And then you also talk about the second meeting. As I go into that second meeting, I have a question in regard to the address of Tegeta's premises or offices, Tegeta. The address.
I'm sorry, Mr. Silega, I missed some of the things you said earlier on.
Yes, Chair.
Are you saying you're going to a second meeting she had with Tegeta or at Saxon Way?
With Mr. Tony Gupta.
With Mr. Tony Gupta?
Yes.
Okay, all right, okay.
But there was just something I needed to clarify with her in regard to the first meeting because of the address. I understand, Ms. Nteta, that, Dr. Nteta, the Tegeta's offices are in Senton, eh? The address is in Senton.
Yes.
And is it correct that you would have known that address during the time of engagement with them prior to them being given the contract or awarded the contract?
No.
From your communication with them
So
by email?
I did. The communication that I had with them was basically via email or on the phone or in person.
Yes. Okay. Now let's go into the second meeting. Could you please tell the chairperson how that meeting came about and what was discussed?
And when it was?
Okay. In terms of when it was, I cannot recall the exact date. But with regards to how it came about, Mr. Tony Gupta
I'm sorry,
called me on my cell phone.
I'm sorry, you can't recall the
Yes.
exact date, but would you recall the year and the
can't-
month, more or less? Which year was it? You can't remember that either.
What I can say, it was, I can't remember. It would have been after the contract was signed, which was from March 2015, but I can't recall
Okay, no, that's fine. That's
exactly when.
fine. Okay, all right, continue.
So Mr. Tony Gupta gave me a call and requested that he would like to meet with me. I indicated I would meet with him. And the reason why I opted to meet with him is because we had been engaging with the CEO, who's Mr. Ravindra Nath, with regards to the current coal supply agreement that Tegeta had with Eskom. Myself, and I don't believe I was alone in that, felt that that coal supply agreement, frankly put, was badly written. There were grammatical errors within it, and we, in terms of fuel sourcing, had been looking to clean it up and just improve it. Also, what I had been working on with the team was a master coal supply agreement, which is a standard template. So also wanting to move it into our standard master supply agreement template. So the team, I had requested the team to engage with Mr. Ravindra Nath, the CEO, on several occasions, and they were not getting any traction in terms of that agreement. And in fact, there was almost of a stubborn not moving, where he would agree to meet, he would be given the agenda. He would then get to the meeting, they would discuss issues, he would say, okay, he'll attend to it, and then he would not. And this had been going on actually for for a while, for some months. So when Mr. Tony Gupta requested for the meeting, I had thought to assist the team in being able to unblock, because I felt that Mr. Nath was being instructed actually not to engage with us and not to do anything with the contract. So I was hopeful, or I can say rather ambitious, in wanting to then address it with their shareholder to request Mr. Tony Gupta to actually instruct his CEO to engage with us so that we can then start to access the contract and move it towards the master supply agreement. So upon arrival at the residence,
just before you move on,
Mr.
Dr. Nteta,
Yeah.
just before you move on, you say Mr. Tony Gupta called you, telephoned you.
Yes.
So would you have given him your contact details?
No.
So how was he able to telephone you?
I will assume he would have received the number maybe from Mr. Nath. I cannot answer where he got my number from.
Could you have exchanged your details with him in your first meeting? Could you have?
No. No.
When he telephoned you, did he tell you the reason for asking to meet with you?
So when he called me, he indicated he'd like to talk to me with regards to the coal supply agreement.
Yes, but what about it?
He just said, I'd like to talk to you about the coal supply agreement. I will be quite frank and say, when I received the call, it was, for me, I thought, great, now we can talk about this coal supply agreement, and then I can request that he asks his CEO to engage with the negotiations.
If he didn't tell you the details, just mention coal supply agreement, did you ask him what about the coal supply agreement so that you can prepare yourself for the meeting?
No, I did not do so because one, what was forefront in my mind at the time was the difficulty we were having with the CEO. So when I received the call, what came to my mind immediately was the opportunity to have him speak to his CEO because we were not getting any traction.
By this time, which is either in middle 2015 or later 2015, did you now, after your first meeting, have knowledge of who Mr. Tony Gupta was?
I had knowledge of who he was after the first meeting, correct?
Did you tell your immediate director at ESCOM that I was called into this meeting, and lo and behold, thinking that I was going to meet with Mr. Nath, it was Mr. Tony Gupta meeting with me?
So I did not inform my directors, my immediate bosses with regards to that. And quite frankly, because the environment within ESCOM was not one of great trust, comfort, so I did not.
I see. Did you tell anybody, because you mentioned to him in the first meeting, that what he wants, information that he wants, or yes, falls within the primary energy division? Did you tell anybody within that division that there is this inquiry by Mr. Tony Gupta?
So I informed I informed the coal operations team with regards to that there seems to be a requirement or a query with regards to the management and operations of that. So they should expect a discussion with Mr. Nath, because at my first meeting I indicated to Mr. Gupta that through his CEO, he should engage the coal operations people.
Okay. But you didn't mention to the division that you had a meeting with Mr. Tony Gupta?
No, I did not.
Okay. Back to the second meeting, you can't remember when, but do you drive again to Saxon World?
Yes, I do.
Just before that, I may have missed something, Dr. Nteta. The difficulties to which you have alluded, that you say you had or ESCOM had with the CEO, is that the CEO of Tegeta?
Yes, it's with the CEO of Tegeta,
And who was the CEO of Tegeta at the time?
Mr. Ravi Nath.
Yes. What were those difficulties?
So the difficulties that we were having was in regards to him engaging with us on discussing and moving the current contract that was signed with them, moving it towards our master coal supply agreement template. And in cleaning up the grammatical issues that were there in the agreement. So he would.
So there was an agreement that was in place already between ESCOM and them?
There was an agreement.
Yes.
Yes.
But there were concerns that you as ESCOM had about the agreement. Is that correct?
Yes, the quality of the agreement.
The quality of the agreement. And you wanted
Yes.
Tegeta and ESCOM to actually adopt another agreement. I think you call it master coal agreement or something like that.
Yes. So we wanted to move it to the master coal supply agreement template that we had been engaging with legal on, and we wanted to use it as a template going forward for all our suppliers. And also there were grammatical issues, mistakes in the agreement. So it was to clean it up.
Yes, okay. And he was he reluctant to do so, or was it just taking long to do what he needed to do for the two parties to get to the master agreement?
He was reluctant.
He was reluctant, and that's where your issues were with him.
Yes.
Okay, all right. But from what you are saying, in substance, there might not have been a problem with the agreement that was in place then, but it was simply not the ESCOM template agreement, and maybe because of grammatical mistakes and so on, it was a little embarrassing to ESCOM.
So yes, there was no issue in terms of generally let me not say that. One of the elements that came out, there was a price PwC audit that was done on a few suppliers within the primary energy space. And one of the things that the PwC audit came up with was in terms of the agreement, the quality of the agreement, and their recommendation had been that we need to improve it, and we need to move it towards, we need to improve it. And for me, the suggestion was to move it towards the master template that I've been working on.
I would imagine that ESCOM would have maybe a template, would have a precedent, an agreement to say whenever we are going to conclude a coal agreement with a supplier, this is the type of agreement we conclude. And that most of the time, the supplier would fit in within the terms of that standard agreement. Obviously, there may be changes here and there, but most of the time, the supplier would accept the agreement that ESCOM normally uses to conclude coal arrangements. Would that be correct?
Your thinking is correct. However, there was no, excuse me. Excuse me.
You want to drink water?
I think I'm fine now. I muted to clear my throat.
All right.
So, your thinking is correct in the sense that there should be a standard template that, particularly in the environment, well, a standard template that can be used for, if I use it as coal supply agreement. However, there was no specific template. And what the practice and what would happen is that we would then indicate to legal that we need an agreement in place for the supply of coal. These are the details in terms of the supplier, etc. And we would engage, and they would engage and draft individual agreements per supplier. Whether they in the background had some form of template that they would have used in general, they would, then
You don't know.
you would have to ask them.
Yes.
So what I had said, because one of the issues is that it would take a lot of time and there'd be a lot of backwards and forth. So I had started working with the legal department to come up with that very template, that we have standard clauses that if there are deviations, we get approval from legal for the deviations.
And this particular agreement with which you were not so happy, had it been prepared by ESCOM's legal department, or had it been prepared by Tegeta or their lawyers?
ESCOM legal department.
Oh. What had happened? They had always been preparing these agreements, and I assume the quality was fine. What happened this time, do you know? Or you also don't know what had happened?
I don't know what has happened. I've had the opportunity last night to read Mr. Bester's
Affidavit.
affidavit. And in Mr. Bester's affidavit, he indicates that he was instructed to get an agreement in place within 48 hours. So I can only deduce, based on Mr. Bester's affidavit, that that is why the quality was not
Yes, was not what
to
it
my
should be.
standard.
Yeah. Okay, I'm sorry. I interrupted. I just wanted to understand why you were welcoming the second meeting, a proposal for a second meeting with Mr. Tony Gupta. So I wanted to understand that.
Yes.
But back to the conversation where Mr. Tony Gupta
Chair.
called you.
May I ask something before
Yes,
you
okay.
move on, because it's important for, yes. Dr. Nteta, if you turn to page 66, paragraph 6.7, just before the chairperson moves on to a different point. Paragraph 6.7. in the light of the answers that you have given to the chairperson regarding a template, how should we understand that paragraph that on 7 November 2014, this is before March 2015 when the agreement was concluded, you say, you sent an email to Mr. Nath of Tegeta attaching co-supply agreement template for their perusal. This is a normal occurrence, particularly for new suppliers
Yes.
that have never contracted with ESCOM. So there seems to be
So what
a template.
I sent through to Mr. Nath, as I indicated to you, each engagement that we have with the supplier, we go to legal and we then indicate to them, we want to have an agreement with them, and they would then draft a CSA template or CSA agreement, and then it would then get sent. But at the time there was no, and perhaps it is just my thinking, there was no signed off co-supply agreement that had standard clauses that day or night, whoever we are dealing with, these are the standard clauses that we always use. The legal department would send us a coal supply template. Sometimes we would simply delete from a previous one, we would delete the supplier name and send it. But there was nothing that was, for what I believe should be correct, is a signed off template.
Yes, that may well be so, but I think
So what I sent to him was something that I had received from legal, because I'd indicated to them that we would be talking to the supplier, and it's something that is an agreement which would have been used for another coal supply agreement.
yeah. But the entire paragraph of your affidavit, 6.7, conveys the message that this was your standard practice or normal practice, as you use the word, in regard to new suppliers. So a template was there, whether it's signed off or not, but there is this template that you would share with the new supplier prior to the agreement being concluded, so that you give them the opportunity to familiarize themselves with what would be the terms of the agreement, to raise concerns if they so wish, and discuss the matter with you.
Correct. So when I say this was standard in terms of new suppliers, so when I say with standard, if a new supplier is engaging with the organization, they have no sight of the type of agreements that are in place.
Yes.
So what we try and do is provide them an example of the type of agreements in place.
Yes, and this is the point.
And that is what I say, that standard, yes.
Yes, and this is the point.
So,
Carry on.
exactly. So when, sorry, yes, sir?
You can go ahead.
So the issue and the concern that I'm trying to raise here is that even though we send them the type of agreements in place, when we engage with legal, they then draft and it, one against the other is not necessarily all the time that it is the same. It would depend on who within the legal department is drafting the agreement, who within the legal department I would be working with as opposed to my colleague, and they would then provide an agreement. But there is nothing that is, what I was looking for is something that would come and be signed off by the head of legal, that this is what we should always send through, because, yes.
Yeah, but the point is this, that prior to the contract being signed on the 10th of March 2015, the supplier, potential supplier, had been given the template of a contract about 4 months before,
Yes.
which template you would have seen, You created an email attaching that template and sending it to the supplier. It is surprising that after such a long period of time, prior to concluding the contract, once it is concluded with mistakes that needed to be amended or improved.
In other words, why didn't you correct the
Yes, it is
mistakes before
surprising.
you signed? In other words, why didn't you as ESCOM correct the mistakes before you signed?
So I sent the agreement 4 months earlier, as indicated by Advocate Silica. And that is where it is. Now, when the 48 hours before that Mr. Bester refers to, what would have happened is that they would, when I say they, legal would have sent an agreement because there would have been a request, can you send the agreement? And then that agreement gets sent again. It does not necessarily mean the same agreement that was sent 4 months ago is the same agreement that we get sent later, because there is no generic signed off template. So the question is, why would it not be corrected and not been fixed before it was signed? I am going to then deduce from the information from Mr. Bester, the 48 hours, is that there was a rush to sign that particular agreement, and the legal department did not thoroughly go through the agreement, because the element of the agreement would be something that it's within the domain of legal, and I don't want to answer that particular aspect. So what I observed after the fact is that there are grammatical issues in it. And whilst there are grammatical issues, let us move to what the journey that we are taking to go to a master co-supply agreement template that is signed off by legal.
Do you know what the grounds of urgency were that justified imposing this 48-hour period within which it had been signed? And from what you are saying, it looks like that imposition, that period might not have been imposed by ESCOM. Maybe it was imposed by Tegeta. Do you know what the reasons were given why it had to be rushed like this in circumstances where 4 months earlier, or even 5 months earlier, you had sent a template to Tegeta? There had been ample time for both sides to look at the agreement, correct whatever mistakes, and sign it. Do you know what reasons were given for this 48 hours ultimatum?
No, I don't know, because I wasn't given the reasons. As I indicated, as I had the opportunity to look at Mr. Bester's affidavit, that is where I then see that it was, he was requested within 48 hours.
Yes. Okay, all right. Mr. Salega?
Yeah, take us then, Dr. Nteta, into your second meeting.
Before the second meeting, let's go to the conversation arranging the second meeting.
Yes.
Did
So as
the
I
two of
indicated,
you-
he gave me a...
Did the two of you agree what the venue would be for your meeting? That is Tony Gupta and yourself.
Yes, so he requested that I come through to Saximat and to discuss the co-supply, to discuss the co-supply agreement.
And you agreed.
Yes. And I agreed.
Why did you agree to go to him rather than him coming to you?
The reason why I agreed to go to him.
You had already been there before in terms of the first meeting. I would normally have expected that a supplier who wants to have an agreement with ESCOM comes to ESCOM, generally. But I will allow for the fact that there may be circumstances where you might say, let's meet at a neutral venue, maybe even let's meet at the supplier's place. But I would have normally expected that ESCOM would say, you come to us, you know. But here, you had already been there first time. Why do you agree to go to the venue to be their venue second time around?
I concede with you that we normally would meet suppliers at ESCOM. We would sometimes meet suppliers at a neutral venue, at the financiers, etc. We do that. And I also concede to you, it is not best practice that to do so. At the time, I was just hoping that I would be able to resolve a matter and unblock, and which is why I agreed. But I will concede that generally, we should be meeting at ESCOM only.
Mr. Silega?
I thought the chairperson might also be interested in this. When I asked Dr. Nteta whether you mentioned to anyone, particularly your immediate superiors at ESCOM, that you had a meeting with Mr. Tony Gupta the first time around, you said no, you didn't, because of issues of trust. You think you can elaborate on that?
Yes, I can. So in the lead up to the initial agreement, if you, the Brakfontein agreement,
Yes.
I had been engaging with the supplier for about, I don't know, about 12, 18 months prior to that. From the time of about January 2015, when my immediate supervisor joined us for the meeting with Tegeta. From that time, from January 2018 to, I'll say, until about March, there was continued requests that from the senior general manager for me to be providing weekly reports with regards to the progress on the transactions, etc. And for me, it built a level of lack of trust or lack of understanding of the genuineness of the engagement. And I, at the time when I was meeting, I did not know that if I then go and let's say complain or inform my superiors that I've had this meeting or I'm trying to for whatever reason, I did not feel that they would then support me, and it might be detrimental to myself and my job.
Okay, I'm not sure that I follow that. As I understand it, Mr. Silega's question was whether you shared with the information with anybody that you were going to have a meeting with Mr. Tony Gupta. The second meeting, is that correct, Mr. Silega?
That she had the first meeting with him.
Yes. So your answer is yes, you did not tell anybody.
No.
Is that right?
Yes.
And you say
Correct.
the reason why you didn't tell anybody was because the environment at ESCOM at that time was such that you did not trust. What did you not trust? That's what I want to get.
I did not trust the people that I worked with at ESCOM. Mm-hmm. I did not trust that I would get the support for what I would want to do at ESCOM. That is the trust that I did not have.
Well, the one person one could expect you to share the information with would have been your immediate boss, is that correct?
Correct.
And at that time, who was that?
My immediate boss at that time was Mr. Mboweni.
Mr. Mboweni. You say you did not trust that they could support you. What kind of support are you talking about? You were going to have a
So-
meeting with Mr. Nath. That is the first meeting, which ended up being with Mr. Tony Gupta. What support are you talking about that you thought they would not give you?
So my immediate boss was Mr. Mboweni. Prior to when we were signing the agreement, he had requested that I provide him with weekly reports. I did not understand where, why, and where those reports were going and why. So I was not feeling comfortable. I did not know, quite frankly, where he stands. So in answering you in terms of the person you should have told immediately would be Mr. Mboweni. I was not comfortable in understanding what would happen to me and sharing with him the information. The kind of support that I'm also talking about. So for the second meeting, we from the fuel sourcing division, we're wanting to open the contract and engage with the contract. And the supplier was not moved. So I did not know as to whether there would be support for us to fix that contract, or they would then say, leave it alone. And I just felt that it needed to move to a master supply agreement.
Did you believe that there was a risk that if you shared this information with Mr. Mboweni, he could ask you not to pursue the line that you wanted to pursue about the contract, or did you believe that he might give information to Tegeta that you didn't want to be given to Tegeta except through yourself at the right time, or both?
I would say it would be both, in terms of just a lack of general trust and comfort. I also believe that I could potentially lose my job, and they could look for something, or, for reason to do so. So it was not a pleasant environment in which to work on, and it was fear.
What is it that you thought they would fire you for?
Sir, I don't know what they would fire me for, but just judging in terms of the corporate environment, they can be anything that they can look for something. So I cannot say I felt it was X or Y, but I just felt that it is not something they would then decide to make my time there very unpleasant or find reason to fire me.
Did you believe at the time that Mr. Mboweni was in one way or another on the side of Tegeta or the Guptas on certain issues between ESCOM and Tegeta?
I did not know. At the time, I did not know.
See, I'm trying to understand your reasons for not sharing the information with him and the issue of the absence of trust that you have talked about, that you did not trust him. Because if you told him that you had just been to a meeting with Tony Gupta and this is what happened, you thought you had an arrangement to meet with Mr. Nath and this is what happened, I don't see on the face of that anything that should make you think if you shared that information with him, you could be fired. So that's why I'm trying to understand, why would you think along the lines of losing your job if you simply shared the information with him that you had been to a meeting with Mr. Tony Gupta and this is what happened?
The reason why I would feel that way, as I indicated before, he had been requesting me earlier to give him weekly reports. What face value would be that why does somebody need weekly reports? Where is it going? Why is it going? And if it is not something that should be requested, why is he not in a position to indicate to whoever is requesting those reports that they will not be forthcoming? So I did not feel that even in his position, he was able to resist any pressures that he was getting. And what would happen is that instead of protecting myself or people within the division, what would simply happen is that then we would then be, I'm going to use a strong word, persecuted. So the environment, though it is, what I'm trying to share with you is that it was not pleasant, it was toxic, and there was lack of trust within the organization. So whether it's my immediate supervisor or someone with people within above him, there was a lack of trust in terms of that I had.
Did you think that Mr.
So sharing with him, sorry, yes, sir?
Yes, continue.
So sharing with him in terms of meeting with them and you know, the irritation that I felt, I did not feel that it's something that would remain between the two of us, and it was a safe environment.
So, are you saying that what you didn't want to share with him is the fact that you were irritated by what had happened, but it would not be the mere sharing of information that you had had a meeting with Tony Gupta that you had a problem with? In other words, the part you did not want to share with him is that you were irritated.
No, the part that I did not want to share was one, that I was irritated. Two, that I had had a meeting with Mr. Gupta. Three, it was, you know, under the guise of meeting with the supplier. I did not want to share with him because I did not know the implications. At the time, I did not know if he was aware of it. I did not know if he was aware that they were going to ask for it. I did not know, because we did not know where information was going, what was the consequences of it, etc. So that is why I did not feel safe.
Did you think that he would not have liked the idea of you having met with Mr. Tony Gupta?
I don't know. I don't know whether if he would not have liked it or he would have been upset that within 15 minutes I left. You know, I don't know. I did not know where he stood. I was uncomfortable about it. And yes, so I did not know whether, even if he was aware and I did not know, but I did not feel comfortable and I did not feel safe.
But how would you report to him, seeing that he was your immediate boss? How would you report to him on progress about this matter if you were not going to tell him that you had had a meeting with Mr. Tony Gupta? How could your report to him be a reasonable one or accurate one if you are going to not tell him about such a meeting?
So I would report to him in terms of the progress on various transactions. It is not the reporting to him on the transactions is not, it was not regular meetings where I would run him through various transactions because we dealt with quite a few transactions. So it's not, the repertoire that we had was not a regular, one-on-one meetings, just quite purely because of the sheer volume of his responsibility.
Did he know that you were uncomfortable with the existing agreement and that you wanted the parties to move to what you called, I think, master coal agreement? Did he know that you had that problem with the existing agreement? Did you share that with him?
I don't know. I can't recall if he knew, but he may have known because, as I indicated to you, PwC provided a report on it. So I can't answer. I can't answer if he knew at the time.
If he did know, do you know whether he would have known because you told him, or he might have known from other sources?
So he might, like I've indicated, he might have known because the PwC report would have been sent to him. So through reading it, he would have then picked up that the agreement needs to be improved. I don't recall having a discussion with him specifically on that. I don't recall, but I know that the report was sent to him. I cannot answer to you whether he read the report or not.
Okay, Mr. Selega, I know I interrupted you. We are at 3 minutes, 4 minutes past 1. Yes. But if there are 2 or 3 questions that you think should not wait for after lunch, you can deal with them. But if you are fine, we could adjourn at this stage.
I'm fine, Chairperson. It will be the next issue.
Yeah.
Yeah, so...
or maybe should we try, if we can, and finish with the content of the second meeting? Or will that, how long do you
Can
think
we
that
do
would
that?
take?
Yes, I would accept that proposal, Chair.
Yeah, let's do that, yeah.
Yes. Dr. Nteta, just before we go on a break, just go into the second meeting then, and what gets to be discussed in that meeting?
So what gets to be discussed is that one of the issues that Mr. Gupta asked me about was looking at he was interested in the difference between what we call medium-term coal supply agreements, for which Tegeta falls within, and also interested in terms of cost-plus agreements, cost-plus contracts, which is where the traditional agreements that were signed in about 1960s. So he was interested to understand what are the differences between the two, who gets a cost supply agreement, who gets a medium-term supply agreement, why do we no longer provide cost-plus agreements? So those are the contents of the discussion that we had. Yeah. Also, the content of the discussion is that I raised with him, I said, speaking of your medium-term agreement, we would like to move it to a template, and we feel that your CEO is not engaging us on it, and requesting that he instruct his CEO to engage with us on it.
Yes. Okay.
That is the content of the discussion.
Yeah. You give us some of that content on page 83 of ESCOM Bundle 14, paragraph 9.6. What I picked up as you go there, between the first and the second meeting, is that, which is one thing you've left out in your explanation, there is one commonality there, the sampling process. coal sampling. It was discussed in the first meeting. It's also discussed in this meeting.
Yes. So in the discussion, in looking in terms of the two, the coal sampling that happens more on the cost plus agreements is because those mines have a conveyor directly to the power station that they are feeding. So the sampling process is different because there's not necessarily stockpiles. Whereas in the medium-term agreement, the coal is mined, it is placed on a stockpile, and then it's sampled, and the samples are taken to labs, etc. So, so those are the differences in terms of the two agreements. So when I was saying, was asking in terms of what are the differences, etc., and also looking in terms of why is the case that on the cost plus they don't have stockpiles, etc.
But doesn't this discussion make you uncomfortable?
The discussion about the cost plus elements.
No, what Mr. Tony
The discussion in
Gupta-
general.
Yes, what Mr. Tony Gupta is seeking to discuss with you, doesn't it make you uncomfortable?
It makes me uncomfortable and it raises concern.
Yes.
It raised a concern to me in terms of also upon leaving, because it was also a very short meeting, was because I then said to myself, I was wondering if they were looking to move towards a cost plus arrangement because they are currently in a medium-term agreement. So I made a note to myself that, be prepared that if they then do decide to open this agreement, because I was hopeful that they would, that they might want to then change the agreement in totality and move it towards a cost plus agreement because of asking in terms of how those mechanisms work.
Yes, but the point I'm making with you is this. You said one of the reasons why you didn't tell your immediate boss is that you don't know
Yes.
what he might say about you meeting with a supplier.
Yes.
And that's where my focus is. That here you are,
Yes.
an employee of ESCOM, you go out of your office. This is not a weekend on a Saturday, you mind your business. You are on duty. And you come being called
Yes.
from your office, you go to the man at his private residence to discuss matters of your work.
Yes.
That's my question. Doesn't
Yes.
that make you uncomfortable? Isn't that something that you, in fact, could have been disciplined about?
I cannot answer as to whether we could have been disciplined about with regards to that, because in terms of meeting with suppliers, leaving our place of work, that is something that does happen. I indicated at the beginning of this discussion to the chair that I concede that it is not best practice to go and meet a supplier outside of the organization. I concede to that fact. Okay. Whether it was done and in terms of a practice at ESCOM, it is, because not only myself, but even our seniors meet suppliers outside of the premises of ESCOM. And it's not best practice. Making me feel uncomfortable, yes, I did feel uncomfortable. One of the elements that I was also uncomfortable about is that where did he learn about cost plus agreements?
Yes.
So, and how much information does he know? Is he verifying this? So those are the kind of things. And I just said to myself, the team needs to be wary that if they are going to open this agreement, that might be something that comes up.
Yes. Well, do you agree that the fact that you did not share with, or maybe let me ask this question first. We know that you didn't share with anybody within ESCOM the effect of your first meeting with Mr. Tony Gupta, is that right?
Yes.
Yeah, at least not with your immediate boss. At least not with your immediate
Yes, not-
boss, yes, yeah.
Yes, yes.
Is that what happened also in regard to the second meeting with Mr. Gupta? Did you also not share
Yes.
it with your immediate boss?
Yes, I did not share with my immediate boss.
Did you share it with other people within ESCOM?
No, I did not share with anyone within ESCOM.
Yes.
I did not share with my immediate boss.
Yes.
But I did not share with anybody, period.
Yes. Would you not concede that therefore it makes your two meetings with Mr. Tony, this makes your two meetings with Mr. Tony Gupta to really be secret meetings within the context of ESCOM? You didn't want anybody within ESCOM to know about these two meetings you had with Mr. Tony Gupta. So you kept them as a secret to yourself. What do you say to that?
Yes, I concede that I did not tell anyone at ESCOM
Yes.
that I met with him.
Yes.
And I kept it to myself.
Yes.
Correct. I did not feel comfortable and I did not trust.
Yes. Okay, maybe we should adjourn at this stage. We'll adjourn at this stage, Dr. Nteta. It's about 12 minutes past 1. We will resume at 2:15. We adjourn.
It's a lunch adjournment, Dr. Nteta.
Okay, thank you.
You can make your way by 12 minutes past 2 or 10 past 2.
Will do.
Thank you.
Thank you.
Dr. Nteta, we are about to start.
Yes, Chair.
Mr. Slager, before we proceed, where are we with regard to the witness who was scheduled for today?
He's around. They've gone out for lunch.
He is around,
Yes, that's Mr. Koko.
Mr. Koko.
Yes, Chair.
Okay,
And his legal representatives. His legal representatives as well.
yes. Should we not talk about what is to happen
Yes,
with regard to that before we proceed?
I think so, Chair.
Because there should be certainty about what is going to happen.
Yes.
Or are they outside at the moment?
Yes, they are out for lunch.
They are out.
Outside for lunch, yes.
Well, maybe somebody could call them in. And once they are in, then we will stop
Yes.
and then discuss what's going to happen. So in the meantime, you can continue, but once they are in, you can indicate to me, then we can.
Thank you, Chairperson.
Yeah.
Certainly. Chair, I think we're done with the second meeting.
Yes, we are done, but let me ask this question, Dr. Nteta. You asked Mr. Tony Gupta to instruct his CEO to cooperate, as I understand it, with ESCOM with regard to moving to a master coal agreement. Is that right? That's what you said you asked him to do.
Correct.
What was his response to that request?
He said he will do so.
Yes. Did the CEO of Tegeta subsequently behave in a manner that suggested that he had been instructed to do so?
No, so to answer you, the agreement was never changed.
The agreement was never changed.
Correct.
Did you speak to the CEO after your meeting with Mr. Tony Gupta with regard to amending the agreement or changing it? And if so, what was his attitude?
I did so on several occasions, and he indicated that he would, but the team never progressed.
Was there a problem from ESCOM's team as such now, or as opposed to a problem on his side, or do you not know where the problem was now?
The problem was always from the beginning from the supplier side. The ESCOM team that was working on it continually tried to move that agreement.
Yeah. Okay, all right, Mr. Slager.
Thank you, Chair. Sorry, a question came to mind as you were asking the questions. Now it's slipping my mind. Dr. Nteta, I would like us to look at before I go into the prepayment, there is a meeting on the 24th of November 2015 which you attended. Can you recall that this meeting, in that meeting, it was yourself, Mr. Koko, Ms. Daniels, on behalf of ESCOM, and the representatives from Tegeta, Oak Bay, and representatives from Glencoe. You recall that meeting?
Yes, I do.
Can you tell the chairperson how it came about that you were invited to the meeting and who invited you?
I recall the meeting. I will confess that I recall the meeting more from the documents that I got sight of, which enabled me to recall the meeting. With regards to how I got invited, I cannot remember if I was asked verbally or if there was a meeting request. I cannot remember how I got the invitation to the meeting.
What meeting was that, Mr. Selega? I missed your question.
This meeting, Chair, what gets to be discussed in that meeting is Glencoe introducing Tegeta Oak Bay as the potential buyer.
So it's a meeting involving ESCOM, Glencoe, and Tegeta.
And Tegeta.
Yeah, whereabout in terms of year, month?
It's 25 November 2015.
Okay, all right.
Yes. Okay. I think Dr. Nteta may be seeking to refer to it in paragraph 8.2 of your affidavit, Dr. Nteta, on page 71. ESCOM Bundle 14, page 71, except that your date is different, unless if you're talking about a different meeting in paragraph 8.2.
So I believe we're talking about the same meeting. As I indicated to you, is that my recollection is more from having seen subsequent documents. So when I was saying it was in December 2015, it may have been in November, end of November.
Yes. So,
But in reference to the participants that you're speaking to, my December 2015 is regarding that. It's that same meeting.
okay, let me cut to the chase by saying this to you. What I wanted to find out from you is why you were invited to that meeting, who invited you, and what was your role in that meeting. There's one particular aspect about that meeting which I wanted you to address the chairperson on, and I will come to it. So it's who invited you, why were you invited, and what was your role in that meeting?
Before she answers, have we got the Mr. Koko and his lawyers around already or not? Are they all there?
Chair, I see it's only Mr. Koko present. They're outside. Mr. Koko, if you don't mind, please call them in.
Yeah, okay, all right, let's continue in the meantime.
Yeah. Those three questions, Dr. Nteta, if you can recall.
As I indicated, I don't recall who invited me to that meeting. I was present, correctly, I was present in the meeting.
Yes.
My understanding or my recollection was that I would have been invited because it's to do with coal supply and working within the fuel sourcing department of primary energy.
Okay.
I can't recall the third question, sorry.
The third question is, what role did you play in the meeting?
Okay. So, and I'm going to indicate that I'm having read documents to refresh my memory. So some of it is based on what I read, but I don't recall if there was a formal indication as to my role. But one of the things was to take minutes. I think Mr. Koko's affidavit said was to take minutes. I can't recall.
Yes.
Was to take minutes of that particular meeting.
Yes. Well, if you can recall, that's fine. I think we will deal with the contents of the meeting in more detail when the other witnesses come. But briefly, this meeting comes against the background, Chairperson, of negotiations for Tegeta to acquire Optimum. Optimum is in business rescue, and there's an offer to buy it from Oak Bay Tegeta. But as at that point, Dr. Nteta, you should also confirm this. As at that point, the sale is, or the contemplated acquisition is only in respect of OCM, Optimum Coal Mine, not the holding company.
Correct.
Not the holding company, Optimum Holdings. But the
Correct.
minutes, thank you, the minutes Yeah. I get a note, the transcribers are saying there's a background noise. Or they can't hear the witness.
By me?
Sorry, they can't hear the witness when she testifies.
The transcribers. Where is
Can they not
the
hear me
statement?
because my voice is soft? Should I bring the mic closer? Is this better?
No, I suspect it's some other technical issue.
Yeah.
Where is Reverend Stemela? He's not here.
He's not here.
Transcribers, are you not able to hear the witness, but you can hear everybody else? Is that so? Okay, so we may need to
There's no sound.
adjourn for them to fix that. We may need to adjourn for them to fix that, but before we adjourn, let us address me on the issue of the witness who was scheduled for today, Mr. Seleka.
Yes,
I see Mr. Berry is here.
Correct.
Representing Mr. Koko, and Mr. Koko is here.
Yes.
Mr. Berry, we are still busy with the witness who started yesterday, but I thought that we need to stop that, and Mr. Selega can address me with regard to what the position is with regard to the witness scheduled for today, your client, so that there can be certainty about what's going to happen. Okay.
Yes,
Mr. Selega, firstly, I think the first thing is how long you think
That's
you still
true.
need with this witness.
Yes, Chair.
Then you can address the question of what's going to happen with regard to Mr. Koko. Are you going to be able to proceed, or what is the position?
Yes. Chair, I think with Dr. Nteta, going into the issue of prepayment, we might take an hour on that issue to an hour 30 minutes. So that's going to take us to roughly, 3:30 to 4. That's the first thing. Mr. Koko, as I understand, was ready to proceed today. And we were ready to proceed with his evidence. I know that there are documentation they are exchanging with us, but I suppose that doesn't stand in the way of us if we are able to proceed to do so. If not in full, at least in part. Because I know that the chairperson's hands are full, and I'm mindful of that as well.
Yes. What did you say about, was there any issue about 3-3 notices in regard to Mr. Koko's evidence?
There was that issue in December, the beginning of the year as well. Chairperson, the ESCOM work stream has attended to the 3.3 notices. So insofar as persons may have been implicated or may be implicated by what Mr. Koko has to say, those people have been notified. So we have piggybacked on our previous notifications and done fresh notices for the people who we see might be implicated in Mr. Koko's evidence.
Well, Rule 3.3 contemplates that anybody who is implicated in a statement by a witness who is going to give evidence should be given a notice of the existence of that statement or affidavit and be given the relevant portions, at least, of the statement. And then the second part is that, of course, the 3.3 notice tells him or her rights or his rights, and then the next part is that he or she should be notified of the date when the witness will testify. For quite some time, what has happened is that Rule 3.3 notices would be served even if the date when the witness would testify is not known yet. But once the date is known, then the implicated person is notified. So if that has been taken care of, then there's been compliance.
Yeah.
Has that been taken care of?
Yes. Chairperson, Mr. Koko has come previously to testify. He's come on 2 occasions.
Yes.
He has given us, or the commission, 2 affidavits. The second of which is a comprehensive affidavit. It includes all the matters.
Yeah.
So his affidavits would have already been shared
Yeah.
with whoever is implicated
Yeah.
or thought to be implicated by his evidence
Yeah.
previously already.
Yeah. Yeah.
So right now, it would simply be Mr. Koko is coming back again,
Yeah.
and this time around he will be testifying on this. You
Yeah.
already have the affidavit. You are
Yeah.
notified of the next 8 years.
Okay, all right. So from your side, once this witness is done and your estimate is that might be about 3:30 or 4,
Yes.
then you would be ready to proceed with Mr. Koko. In terms of how much time is required for him, how much time is required for his evidence on your assessment?
We had scheduled Mr. Koko for the whole day.
For the whole day?
Yes, Chair.
Okay, so you think what's necessary is a whole day?
Correct, Chair.
So if we start when we are done with this witness, we could go up to a certain point and then
We will have to reconvene.
then maybe subject to their availability, maybe continue tomorrow to finish before we take tomorrow's witness.
Yes.
Mr. Berry, you have heard what the situation is now. What's your attitude?
I have no particular attitude regarding the issue, apart from the fact that we have arranged to be here today, but not tomorrow. We have had no idea that there is any possibility.
Yes.
This is not a rolling,
Yeah, no. I said,
Because-
I talked about tomorrow on the basis of saying if you are available. Obviously, you had not been told about
I
tomorrow.
go back to the Western Province tomorrow morning.
Yes, no. So you would be available that we use whatever time is available today, but if we don't finish, then another day would have to be arranged.
As you please.
Yes. Okay, all right.
Chairman, there's just another issue, and
Yes.
my colleague here is in relation to the issue of the ESCOM application to cross-examine. It would be appropriate for some arrangements to be made about that particular issue.
I've been told by Mr. Selega about an ESCOM application for leave to cross-examine. I have not seen it, so it must be somewhere within the Secretariat's offices. And I indicated that I can't say anything about it until I've seen it and read it. So obviously, that's not your fault that it hasn't reached me. I've asked Mr. Selega to speak to the Secretariat to make sure that I get it
Mr. Chairman,
without delay.
we oppose the application for various reasons, but we will probably have to deliver a shortish answering affidavit to the affidavit that was delivered. That sort of
Yes.
cites Mr. Coco as a party.
Yes.
So, which we can do. It's just a question of arranging the logistics and when that application will be heard.
Well, the process is that once an application for leave to cross-examine a witness has been lodged, the person lodging that application, I think, is supposed to serve on the witness a copy of the application. But in any event, if they don't do that, the Secretariat would check whether a copy has been served on the witness, and if it has not been served, then...
That has indeed happened.
That has
We
happened.
do have the application, yes.
Yeah, and I think then the rules are supposed to indicate within what period the witness should file an answering affidavit if they oppose. But if they don't do that, namely the rules, then I should issue directions as to when that application should be filed. But as I say, it has not reached me, so I didn't know about it until
I'm
a
not
few
aware of
hours
any provision of the rules that make
Yeah,
any
there might not
particular
be.
provision.
There might not be anything in the rules. Well, you already have the application. Why don't we deal with that now? Can you file your answering affidavit within 7 days, calendar days from now?
We would be able to, yes.
Yeah, let's take that as the direction as to when to file.
Yeah, the real issue relates actually to the date of the hearing.
Sorry?
The real issue relates to the date of the, when the application will be argued.
Yes, yeah, but we need to have all the papers in first. Then we can talk about the date for hearing. Some of the applications, we don't have oral argument. We just ask the parties to file written argument, and then I decide them in chambers. But I take a view on that once I see all the papers. So I think file your answering affidavit within 7 calendar days from today, and ESCOM should then file their replying affidavit if they wish to do so within 7 days after you have filed yours.
Very well.
Okay? All right. Okay. Thank you.
Thank you, Chair.
But the upshot of all of that is, apart from the ESCOM application, we must stay here.
Yes, yes, okay, yeah, stay here. Obviously, the commission's legal team, if they want to oppose, then they must also file within 7 days. If they want to oppose within 7 days from today.
That's
Okay.
the order, Chair.
Yeah. Okay, all right. Okay, let's continue then.
Thank you, Chair. The technical issue has been sorted out. So
Okay.
that they can now hear the witness.
Okay, all right.
Dr. Nteta, yes.
Thank you.
Yeah. And then, in regard to that meeting, quickly back to that meeting, or prior to that meeting, what was on the table between the parties negotiating for the sale of OCM, it was that only OCM was to be sold. Do you recall that, or you have no recollection?
Yes, when the meeting commenced, we were discussing OCM,
Yes.
Optimum Coal Mine.
And in that meeting, in particular in regard to the sale, the minute indicates that Mr. Koko then advised the other parties that Eskom will consent to the sale, and I paraphrase, only if OCH assets are to be sold.
I am silent because I don't recall the details, so I will bear that the minutes would be a true reflection unless otherwise indicated. For example, who suggested OCH, etc. I don't recall.
You don't recall that.
But I will take, but I will take that the minutes reflect the discussion.
Yes, but you have seen both the affidavit of Mr. Koko and Ms. Daniels.
Yes, I've seen them. Mr. Koko's received last night, so I did not, and it's 1,040 pages. So I did not go through everything.
Yes, and Ms. Daniels, because she also talks about this meeting.
Yes, yes. And that's where most of my recollection comes to, and I'm relying on the information that she's indicated there.
I see. Okay, we will deal with the matter with them when they come in due course. Let's go to the prepayment. The 59 million prepayment that the BTC resolved to make on the evening of the 11th of March 2016.
11th of April.
11 April 2016. Thank you, Dr. Nteta. This decision that gets to be made by the board tender committee starts with the drafting of a submission, which,
Correct.
yes, which you started.
Correct.
But then something would have triggered the drafting of that submission, and I want you to tell the chairperson about what triggered the drafting of that submission.
The drafting of the submission emanated from a discussion that I had, several discussions that I had with Mr. Ravi Nath, who is the CEO of Tegeta. They were currently supplying coal and the agreement for that was due to end. He indicated that they have access to the coal and they would like to continue supplying Eskom with the coal.
Okay, just pause there for a
As at
moment.
the,
Just pause there for a moment. Now we know that Tegeta, at this time, this is April 2016, it has an agreement, a coal supply agreement with Eskom in respect of Brakfontein mine.
correct,
That agreement was concluded on the 10th of March 2015. So that's the year before this.
correct,
Now, Mr. Nath is coming back to you in respect of a contract for a different mine.
correct.
And which mine is this?
Optimum coal mine.
And when he comes to you, then I think you could tell the chairperson, when exactly does he come to you? And what is he saying to you?
So Mr. Nath came to me, I'm not going to, I do not know the exact date, but I'm going to say around about end of March, beginning of April, where we had discussions with regards to coal from Optimum Coal Mine. At that discussion,
I'm sorry.
should I continue?
When you mention the month, please always mention the year as well, because we deal with different years, so that we are all on the same page as to much of which year that you are talking about.
March 2016.
Okay, continue.
So we had the discussion with regards to availability of coal for them to supply to Eskom. And there were a few discussions that we had. Advocate Seleka, I've actually forgotten the question, sorry.
Okay, please repeat the question, Mr. Seleka.
Yes. Okay, you've indicated when does he approach you? And I think you've touched a bit on what does he discuss with you, but go a little bit into the details. Here's Mr. Nath. How does he communicate with you? Is it telephonically or is he coming to see you? And go into the details of what he's asking you.
So the discussions that I had with him were both telephonic and also meeting with him in terms of the discussion. Also because that would be the nature of the engagements that I would have with him as a supplier, either telephonically or meeting
in
with him,
person.
and both.
Meeting in person.
Meeting in person, yes.
And where do you meet?
So
Where do you meet with him? It's not Saxon World.
At Eskom. No, at Eskom.
Okay. So he comes to Eskom.
Yes. So the discussion.
Speak up, Mr. Seleka, your voice is very soft.
Yeah.
So raise your voice.
So Mr. Nath comes to Eskom to meet with you.
Yes. So the majority of the engagements that I would have with Mr. Nath would actually be telephonic. He would sometimes come through to Eskom. So in responding to your question in terms of the engagements that we had that led up to the drafting of the submission, the majority of the engagements were telephonic. And I do think I would have met him as well in person, maybe once, but mainly telephonic discussions.
Yeah.
The discussion.
Was it you initiating this engagement or was it him?
It is him.
It was him.
So yes, the nature of supply with Eskom is that the suppliers would then indicate that they do have coal availability, and then we would take the discussion further.
Unsolicited.
unsolicited, yes.
Yeah, so even in this
That we called
case,
it.
go ahead.
So even in this case, he indicated that there is availability for coal.
Yeah. So I want to be absolutely clear, you didn't invite him and ask him whether they have coal or not.
No, he indicated that they have coal.
Okay. So what then does he say to you?
So the initial discussions were that we have coal available. At the time, I cannot recall if we actually spoke about the exact tonnages that were available, but I expect that it would have been maybe similar to the tons that they currently supplying. But anyway, they indicated that they've got tonnage and coal available. So those are the initial discussions.
And where would they obtain this coal?
From Optimum Coal Mine.
And supply which power station?
So to supply Arnott Power Station, and it could also supply Creel Power Station as well as Hendrina, but the main issue was for Arnott Power Station based on the coal quality.
Yes. Remember, I want you to tell the chairperson what he told you.
Yes. So the initial discussions were in terms of, we have coal to supply. As I indicated to you, they were previously supplying coal to Arnott Power Station. So it was to say that we do have this coal for this particular quality that we can provide to yourselves. As I indicated, I can't recall if he gave the volumes or not. And we had a few engagements with regards to purely on the supply of coal.
Was price indicated?
The price indicated, yes, would have been discussed at one of the engagements that we had.
Was Arnott Power Station not being supplied?
So the history behind Arnott Power Station is that Arnott Power Station had previously been supplied coal through an agreement with Exxaro. However, for quite a few years, they were not able to meet the demand, the coal volumes that are required for Arnott Power Station. So there were several suppliers that would supply coal to Arnott, and this was more on an ad hoc basis. There was no stable, secure supply for Arnott Power Station. One, because of the volume that is required for the power station. Secondly, because of the qualities, the requirement was a higher quality, and the market that was generally a bit difficult.
Yes. So what do you do with Mr. Nath's approach to you in regard to having to supply coal?
So we discuss it, and we discuss also in terms of the volumes and availability. Later on as I indicated, we had several engagements on the topic. Later on in the engagement, he then indicates that in one of the conditions that they have for the supply of coal is that they would require Eskom to prepay for that coal.
Okay, well, just make us understand. The engagement is over a number of days.
Yes, I'd even want to say maybe even a week or two, but it was over a period.
Yeah. You have said in your affidavit at the beginning of his approach to you, he did not indicate that they required a prepayment.
Correct. So the initial engagements that I had with him was that we have coal on offer to supply to yourselves, and there wasn't a discussion with regards to prepayment. As I indicated, that there were several discussions. It was actually to the end of the discussions in April where he then indicated to me that one of the conditions for the supply of this coal would be that Eskom prepays for this particular coal.
How did that sound to you? Here is somebody who wants...
How did this sound to me?
Here is somebody who wants business from Eskom, but now is already putting conditions. Wasn't that strange?
Yes. So for me, what it sounded like is that he was gauging our appetite, and I would say it was a negotiation tactic that he used. He was gauging our appetite in terms of, are we interested in the coal? And yes, I did indicate that we are interested in the coal because we have a requirement for it. And then once understanding that we do need the coal, then to say, well, now that I know that you need the coal, this is a prepayment. So for me, it was a negotiation tactic that he used. And so at that point was then when I then realized that, okay, because if it's a pure requirement for coal, it goes to the medium-term mandate where it's sign off in terms of the head of primary energy. But with the prepayment, for me, then it indicated to me that this was something that had to be discussed in terms of in the area of finance because they deal with payments.
Well, you see, part of what comes across as strange to me is the language that you say he used. He wants business from Eskom, but he's putting a condition. He's not saying, we would request you to agree to do a prepayment because we are in this particular situation. He's saying, I want business from you, but before I can have business with you, I'm going to put a condition that you must comply with, as if you are the one who needs him more than he needs you. And maybe that was the situation in terms of his knowledge of how dire Eskom's need was for coal. But it comes across as strange to me for somebody who is looking for business to start putting conditions as opposed to making a request or just a proposal.
Noted, Chair, and I will ask that you excuse my language that I used. I did not indicate what he said verbatim. One, because of the time that has taken.
Yes.
Yes, so it was not verbatim.
So
perhaps I should have said there was a request. Yes, there was a request for a prepayment.
Or he put it as a request? Or you can't remember?
I can't remember his words verbatim in terms of what exactly that he said. I'm saying that I have used my language,
yes,
which I do not want to misrepresent.
Yes.
That that's what he said. For me, it was that before I can accept this call, there's prepayment. So I use my own language. Apologies for that.
Okay, all right. Mr. Slega?
Yes. But I think also the emphasis, or the focus rather, Dr. Nteta, was in your observation that this might have been a negotiation tactic. That once
It could have been.
Once I've gotten you to agree that you needed coal, now I can move to my next step of negotiation, which is, but can you pay me up front before I give you the coal?
As I indicated, that possibly could have been a negotiation tactic.
Let's get certain things in place here. The Arnott Power Station, you say it had been supplied coal by Azaro, a company called Azaro.
Correct.
Do you know until when did Azaro supply Eskom with coal at the Arnott power station?
Exxaro supplied Arnott with coal up until, I believe it is December 2015, when their contract ended. They had a 40-year contract with Eskom.
December 2015. Now, after December 2015, do you know what happened in regard to the supply of coal to Arnott?
So the supply of coal to Arnott, even prior to December 2015, was being supplied by several contracts, short-term contracts to supply Arnott. So some of those shorter-term contracts continued post-2015, and in other instances, we sought to find additional suppliers to Arnott Power Station. I had also issued an RFP, which looked to find additional sources for Arnott.
I heard you say that Tegeta had a contract and it was about to expire. Could it be one of these short-term contracts you are referring to that Tegeta had to supply to Arnott?
Yeah, Optimum, yes, they were supplying Arnott with coal in the period up to April.
Yes, as I see the evidence, there was an agreement with Tegeta in January 2016 to supply Arnott. You are aware of that agreement?
Yes.
There was also
So I think there were two agreements, if I remember correctly, but perhaps you can clarify.
Then there was one in February 2016. I think there was a third one, or if not that particular one, which was about to end sometime in April 2016.
If my memory serves me correctly, there were two.
Yes.
And the second one was the one that was due to expire, yes, in March or April.
Yes. Now, according to your recollection, were those agreements with Tegeta based on a prepayment?
No.
Then in April 2016, when Mr. Nath approaches you, was this the first time that prepayment was mentioned to you?
It was the first time the prepayment was mentioned to me by Mr. Nath for Tegeta.
Yes. And this would have been still to supply the same power station, Arnott.
Yes.
Why do you take such a long time to answer? Is it because the sound comes late to you?
Yes, it does. Particularly when I speak, then I hear an echo.
Oh,
So I was just trying to figure out what that was.
okay. If you have, well, just for the purpose of the chairperson, Chair, the aspect regarding the prepayment is dealt with from page 71, Eskom Bundle 14, page 71 of Dr. Nteta's affidavit, under paragraph 8.
Yeah, of course.
So, Dr. Nteta, if this was then the first time, well, the first time you were approached by Mr. Nath regarding prepayment, but had you dealt with a contract that required prepayment before this approach by him?
Personally,
Yes.
no.
No. So what did you do? How did you handle the matter?
So at the end stage, when he indicated that he required a prepayment, I thought it prudent because I have not dealt with personally prepayment myself. And I also recognize that through the segregation of duties, it is not something within my domain and realm. It's something that, you know, would have to be looked at elsewhere. So what I then did is I actually went and I sought guidance from my principals. I initially went through to Mr. Mbowene's office. He was not available. And then because they sit in the same area, I then went to Mr. Mabilani, who at the time was the CPO for ESCOM, and indicated to him that I have been approached by the supplier to supply us with coal for Arnold. While, yes, we do require the coal, they have then requested a prepayment. And I sought his guidance in terms of how would I then handle this particular matter.
Yes, and what was his guidance?
Under his advice, he then indicated that he thought it best that we take the request through to the BTC so that they can then, board tender committee, so that they can then apply their mind in terms of this particular request that we received from the supplier. He felt that it was rather prudent to do that instead of within primary energy adjudicating it because of the issues of the requirement for prepayment. So based on that, then that is when I then said, okay, I will do so and then start. Sorry?
Yeah, continue.
So based on that, I then, based on that, I then said, okay, and then began to start working on a submission to the board tender committee.
At the time you started working on a submission that would go to the tender committee, did you have something in writing from Tegeta formally making this request and giving motivation for it?
No, sir.
Is the position that all you had was just the either telephone conversation that you had with Mr. Nath or a meeting where he made this request?
Correct, sir. So oftentimes when we get unsolicited offers to provide coal, those unsolicited offers come in the form of a meeting or a discussion where suppliers will come through to us and then say we've got particular coal requirements, etc. And then we would work from that. At some point within the discussions, we will then say, okay, provide an offer. I will say that not all my colleagues do that because it's not something that it's not all my colleagues do that, but would normally refer to an approach. We say an approach was made by a supplier. So at the time that I started working on the document, there was no formal letter. We'd been discussing for about a week or so, and there wasn't a formal letter that I received.
During your discussion with Mr. Nath, did he indicate to you how much amount he was talking about in respect of prepayment?
He didn't indicate the rand value. As I indicated before, at the beginning of our discussion, I can't recall if we spoke about when the issue of the monthly volumes were, but he didn't indicate the figure in terms of the 659.
So when you were preparing your submission to the BTC, what amount were you going to talk about if you had not asked him what amount he was talking about?
So the submission for the BTC was based on volume and the cost of coal. So the request was, we would like for you to prepay for the coal that we're going to provide to you over I think it's 5-month period. So it was rand per gigajoule times the volume.
So are you saying, although he did not mention the amount, that is Mr. Nav, the amount was ascertainable, easily ascertainable?
Yes, he mentioned the volume and gigajoule, and that is it. So we multiply the volume by the rand per giga, the figure.
So at that time, there had been no agreement, or had there been agreement on the price, and so
There wasn't
many
a-
tons or whatever.
There was an indication of the price in terms of a rand per gigajoule.
And there was an indication of the price that ESCOM was prepared to pay, and that seemed to be acceptable to them, or what was the position?
So in terms of the unsolicited offers, is that the suppliers would indicate the amount of coal that they have to offer, and then they would then indicate the cost of that coal. And that is what they would advise us in an approach, to say that we believe that we will sell you this coal at, I'm going to use a simple, at 10 rand.
Yeah.
And we've got 100,000 tons.
Yes. And and the position was that whatever price they had indicated was acceptable to ESCOM as far as you were concerned. At
No,
that
so
time.
when they provide us with so they would indicate what the price is. And so what we then do is then we would, one, look at negotiating in terms of their pricing. We would also then, or if we're taking it to the board committee, the tender committee, we would then indicate that this is their offer price, and then we get a mandate to then enter into negotiations with them, and then we would negotiate it from there.
Okay, so then at some stage you would go back to them to say your price is acceptable or your price is not acceptable. Here is our counter offer as far as the price is concerned.
Yes.
Okay, so when he spoke, he requested a prepayment. Is the position that what he meant was, before we deliver to you so many volumes of coal, we'll ask you to give us the payment for that coal, that amount of coal. In other words, whereas normally we would deliver coal first and then you pay after, this time we want to reverse the arrangement. We want you to give us the money first, then we deliver the coal. Is that what his request meant?
Yes.
So the prepayment, the money that ESCOM was going to pay if it went along with his request, was always going to be determined by the price that is agreed for coal and the volumes of the coal. Is that right?
Yes.
Okay, all right. Mr. Slega?
Thank you, Chair.
Correct.
Yes. Dr. Nteta, in paragraph 8.4 of your affidavit.
I'm sorry, Mr. Slega, again.
Yes.
You did confirm that at the time that you started preparing the submission that would go to the BTC to ask for approval for the prepayment arrangement that was requested by Tegeta, you did not have anything in writing from Tegeta making this request for prepayment and giving motivation as to why, in their case, there should be a reversal of the arrangement, namely, you must pay them first for coal that you have not received, and then they deliver the coal. Now, what reasons had he given you verbally when you were talking about this? What motivations did he give?
So the motivation that he gave in terms of the prepayment, the requiring the money upfront, was that they required to open up the export portion of the mine, because when Optimum went into business rescue, and I think it was actually from August the year before, but I stand to be corrected on the time, they had closed down the export portion of the mine. So in order they needed to restart the mine, and they needed the funding to restart the mine so that they can provide us.
Effectively, he was saying that Tegeta didn't have money to restart one of its operations. Is that correct? And therefore, that's why
Yes.
they wanted Eskom to pay in advance for coal still to be delivered so that they could restart one of their operations. Is that right?
Correct.
Yes. Would that be a sound reason for Eskom to engage in prepayment? I know that you said, I think you had not dealt with prepayments before, but you were, I don't know whether the chief negotiator, but you were a senior person talking to the CEO of Tegeta. That just doesn't sound right to me. If I want to do business with you, we must do it the same way I do it with everybody normally. We must have an agreement that you will provide me with coal. Once you have delivered coal and I've looked at the coal, is it acceptable? The quality is fine. Then I pay you. This idea that I must pay you first for coal that I have not yet received because you want to run your business or restart one of your operations doesn't sound right to me. Did it sound right to you?
So in terms of the understanding, this particular principle had been applied before, circa 2008, where we had some emerging miners who needed some funding upfront so that they're able to beneficiate coal. Because we also recognize that the industry of coal mining is quite capital intensive and it's quite cash intensive. So it has happened before, and a lot of times the suppliers do indicate to us that the generating the initial cash is an issue. So it made sense to me because I understood that the export operation was no longer operational and they needed some funding. So it made sense to me. But with regards to the operations, etc., that would have been in the domain of the operations department to ascertain those elements.
Does this type of situation, let's leave out the question of maybe assisting previously disadvantaged suppliers, maybe who might need some assistance, leaving that consideration aside. When a supplier makes this kind of request for the reasons that Mr. Nath gave you, wouldn't that give you some discomfort that you may be entering into a very important contract with somebody who doesn't have financial stability, and that might threaten the contract that you might enter into that you might conclude with them. Their financial situation might be precarious, and it might not be in the interest of ESCOM to go into a very important contract involving millions of rands, maybe billions, with an entity that maybe could go into business rescue anytime, or which could be liquidated anytime because they are not in a financially strong position. Wouldn't that situation that they had be a kind of a red flag to say, should we really continue with this arrangement? Is there not too much of a risk?
So one of the challenges that we have within the procurement fraternity, and when you look at unsolicited bids, is that when we receive an unsolicited bid, we need to look at that bid and entertain that bid and see if it's something that can be done. Because we then fall on the other side that if we then independently, and I say myself, if I independently then say no to a particular supplier and yes to another supplier, then there's often challenges. So one of the issues that we had was that when suppliers come and they put in certain requests, we would look at them and entertain those requests and see if it's something that can be done. So when the supplier, in this particular case it was Tegeta, comes through and says that we have coal, we request you to prepay for this coal, then I would look at that coal, that request, and then see in which is the appropriate mandate to then further interrogate it. At face value, I would not be able to say no to them or to any other supplier. And that's a challenge of unsolicited offers.
But do you accept or do you not accept that it would be in the interest of ESCOM to look at what the chances are that an entity that they might conclude a coal contract with that involves lots of money over a long period of time might not be an entity that's going to be around for a long time?
Yes. So the agreement, when you look at the agreement, was 5 months. So in the time frame of ESCOM, 5 months is considered a short time. So it's not, we don't consider it a long agreement. So it was considered for a short period of time. And then we would then look in terms of what can we do to mitigate our risks.
Mr. Silega?
Thank you, Chair. Dr. Nteta, this matter also has to be looked at against the background facts that prevailed at the time. So Tegeta had the short-term contracts already from January 2016 with ESCOM supplying to Arnold. In fact, those contracts are 3 in number. And the one of those was about to expire, the third one was about to expire in April. Now those contracts, you have said, well, you understand them to be 2, but they are in fact 3. They were not concluded on the basis of a prepayment. Do you recall that you did the fuel sourcing in respect of those contracts?
Correct.
You did.
Yes, so I think the question you broke up a bit was that they were not concluded in terms of the prepayment, and I'm saying correct.
Yes. But also that you were involved in the sourcing of that fuel, of those contracts.
Yes,
So you know
Yes.
that there was no prepayment.
Yes. yes,
Yeah. Now, this is the fourth, I beg your pardon. This would be then the fourth agreement in respect of which they are making an approach to ESCOM in 2016. Correct?
yes,
Which is also a short-term agreement.
yes,
For 5 months, you say. For 5 months.
yes,
But when they come this time around, they are asking for a prepayment.
correct.
But they didn't ask for it at inception of approaching you.
Correct.
You don't know, or do you, what suddenly made them to come up with a prepayment requirement or request?
No, I don't know what suddenly made them come with a prepayment requirement, except for what they indicated to me.
Yes. Was that reason you gave about they needed funding to open up the export coal mine, is that their reason?
That's the reason that Mr. Nath gave me, yes.
You can recall that for sure?
Yeah, he spoke to me on the phone because when he asked me for the prepayment, I did ask him why he wanted the prepayment, and then he said, no, we required it for the funding, etc. I also indicated to him on the phone, I said, hey, I'm just asking, but I'm not saying whether it's something that we would look at or something that we wouldn't look at. So that's what he indicated to me.
Okay. Can I accelerate my question? Because I will come back step by step. Did you give that reason to Ms. Suzanne Daniels?
I can't recall if I gave it to her verbally or not. I really I can't recall if I gave it to her verbally at any point. I know that Mr. Nath did tell me about it, but I really can't recall if I told her over the phone or I didn't tell her, etc.
Did you give it to her in writing?
If it was in writing, it would have been in the submission document.
Well, your submission document.
So in terms of the submission document, I had a lot of engagements with both Suzanne and a lot of engagements with Edwin and copying also Mr. Mbo. Mr. Koko, giving me feedback. So my not being able to say if I told her on the phone or I didn't tell her, I'd rather say you should look at the email trail to indicate as to if I told her or not, because I would have put it in the submission if I did.
Maybe continue, Mr. Selega. Yes. I've got some question, but just continue.
Okay. Okay. We will go to that submission in due course, Dr. Nteta, because in your email to Ms. Daniels, you specifically said you didn't deal with the prepayment. It is in the resolution, but you didn't deal with it.
Yes. So in one of the many engagements that I had with Suzanne, because I'd also spoken to her, so in making amendments to the document, I sent her an email with the document just to highlight to her that the issue of prepayment is only in the resolution. It's not in the body of the document, so that she's aware that it's not in the body of the document. And she would then be able to provide guidance as to whether it needs to be in the detail of the document or not.
Yes, but what I'm trying to find out from you is whether you told her in writing, or you were saying you can't recall verbally, but did you tell her in writing?
Advocate Sileka, as I said to you, I cannot recall.
Okay.
I would have to go and look at the emails, really, because there were a lot of engagements back and forth.
Because,
If it's not in the emails, then I will then say that I did not give it to her in writing.
because I'm trying to get certainty from you in regard to, is it as a matter of fact that Mr. Nath gave you that reason, that this is the reason why we want a prepayment?
Mr. Nath gave me that reason on the phone, yes, when I asked him, why do you want the prepayment?
Okay.
And that was at the very initial request for the prepayment.
Yes.
For example, if, yeah.
Yes. I see that you have made a distinction between that request for a prepayment and the initial approach, which was, as you say, for coal.
Yes, I make that distinction
Yes.
because at the beginning of our engagement with Mr. Nath, it really was about coal.
I see. And that means, tell me that is a correct understanding, when they approach you regarding coal, they are saying, we have coal, we can supply you immediately.
Okay, you broke up a little bit, so I'm going to repeat what I think that you said. That their approach to me was that we have coal that we are able to supply to you.
Immediately.
Yes, and so when my first discussions with him was that we have coal that we are able to supply to you.
Thank you. But the prepayment brings a completely different scenario in the picture.
Correct.
What it means then, in terms of the prepayment, is that we do not have the coal. We want to open the export coal mine. You say maybe it's the coal component of the mine, export coal component of the mine. And once we have opened it, we will mine the coal, and in due course, we will have it available to supply to Eskom. Is that a correct
Yes.
understanding? Okay.
Yes.
Was this a situation where he was saying, the money that we would like you to pay upfront to us, whatever we need to do with it is necessary for us to be able to then give you the coal that we are talking about? Was it that kind of situation? Or was the position that we will give you coal, it's not dependent on you giving us a prepayment, but we need you to give us prepayment for other operational reasons for our business?
So it was, we require you to give us coal, to prepay for the coal that we will give you for the 5-month period.
So,
Yes.
yes, continue.
I want to just note is that my discussions with Mr. Nath did not, they were on the prepayment aspect, were very limited because I really did not want to give him the impression that we are accepting his offer because of this requirement for the prepayment. So my discussions with him were more in terms of why do you want it, so that we're able then to, to understand it. I mean, it was a question of, if you ask me for something, when I ask you, why do you want it? And when you then talk about payment, those elements would be negotiated and there would be understanding on the payment aspect of it as to is it required, is it not required, etc. So it wasn't great, long, intensive discussions that I had with him.
Yes, I can understand that attitude at a certain level, but I would imagine that before you put pen to paper in preparing submissions to the BTC, you would want to have a full understanding of what they had in mind, or of what this money would be used for, and what it would mean if you were to refuse as ESCOM to make the prepayment. So that's why I'm asking the question whether you understood him to be saying, we need the prepayment because whatever we are going to do with that money needs to be done if we are going to be able to give you the coal that we are talking about, or whether the position was, we, irrespective of the prepayment, we will be able to give you the coal that we are talking about, but we think you should give us prepayment for this and that reason.
It is scenario number one that you picked, that you indicated.
It's scenario number one.
Yes,
Okay.
it wasn't, they were not going to give us coal irrespective.
Yes. So what was your understanding of what they would do with the money in order to be able to give you coal?
My understanding of what they would do with that money would be to beneficiate the coal. So they were going to open up the export portion of it, so that they're able to beneficiate the coal and then provide it to us. That was my understanding.
So in other words, they were not in a position to enter into a coal agreement with you and deliver coal to you without you giving them a prepayment.
That is my understanding.
Yes. Now the prepayment, was it going to be the whole amount or the total coal that they were going to provide during the contract period? Or was it going to be in tranches of certain amounts according to certain volumes that would be delivered at certain intervals?
The prepayment was for the 5 months contract that they had, where it was to be provided upfront, and then they would deliver over those 5 months.
So you would give them like R500 million straight away, and then over 5 months, then they would deliver this coal to you.
Correct. Correct.
And did you apply your mind to the question of what security does ESCOM have in terms of this money that it will pay in advance in case something happens to Tegeta and then they are not able to deliver this coal? What arrangement or what security did you think would be put in place to protect ESCOM in that regard?
So yes, I applied my mind. I asked the question to Ms. Daniels in the looking at the submission to say that, okay, if ESCOM agrees to this, what security do we have? And there needs to be some form of security.
And what did she say?
So, and that is where the discussion in terms of the security, in terms of, there's a very I just can't remember the right wording, but security in the form of the shares and their Braakfontein, the shares in terms of Braakfontein was the suggestion that she had.
Was it something you understood that she told you about in terms of security, or is it something that you didn't understand but you left it with her because she was a legal person?
So I had limited understanding in terms of the security because I believe that she's a legal person. I also believed that on the finance side, they would have to do the calculation as to whether whatever security that is being offered, is that adequate? So for me, it was, how do we mitigate the procurement risk? And they said we can do that with regards to legally, and then the finance would then look in terms of, is that adequate?
Of course, you ought not to support a submission that ESCOM should agree to Tegeta's request for prepayment unless you understand that there would be an adequate security arrangement. You agree with that? So,
Correct.
So if a legal person tells you some legal things that you don't understand, you won't support it until they can tell you in a language you can understand, and you can reason it out yourself and say, okay, I do understand, so I support this. Is that correct?
That is correct. So as I indicated to you, I had a basic understanding in terms of the securities that were available. Also understanding that when you send the submission through to BTC, the mandate is that for those who are best able to negotiate those particular aspects, then they do so. So I understood that, well, we have, I think it was a 7-year contract, and there's shares and there's value in terms of the aspect of the bigger security. So it would make sense that we are able to then put in some sort of a claim on that coal, should they not do so.
I would take it also that before such a prepayment would be made, at least some investigation would be conducted by ESCOM into Tegeta or any such entity, because you don't want to put in R500 million of your money into this entity because there is this agreement about coal, and only to find that it is up to here in debts and in a few days' time it's liquidated. So I assume that there would be an investigation conducted by ESCOM to look at such risks.
So there are two aspects of it. One is that when we are looking in terms of new suppliers, there is an investigation that happens in terms of the financial statements, etc. When it's suppliers that have been in the system and have been supplying coal, we generally don't look in terms of their financial viability, etc. However, having said that when you then look in terms of there is a risk that is involved of paying certain funds up front, then those that then say that we should take this risk would need to do some sort of risk mitigation in terms of that.
And then what I do find a little strange is that for something like this, you were prepared to go to the extent of preparing the written submission that would go to the BTC without having asked Tegeta to put their request in writing and provide their motivation, so that as you prepare your own submission, you have something from them in writing that says, this is the request we're making, this is our motivation for it. Is there any reason why you didn't ask them to give you something in writing?
So I note that you say it is strange. However, when you look in terms of the practice, what we do is we would draft a submission and we will indicate that we have been approached by the supplier. Therefore, it may be an approach in terms of an email, it may be an approach in terms of a meeting, etc. And we then draft submissions. I did request the supplier, while in the process of drafting the submission, to then provide a formal offer letter for the coal.
And they did.
But it is strange, as you indicate that it's strange, it is practice.
Yes, but did they provide it in writing after you had asked?
Yes, so the supplier provided an offer letter. In fact, I contacted the supplier. I continue because I suspect Advocate Seleka is going to ask me these questions. I contacted the supplier and asked them, I said, I require an offer letter in terms of the coal that you have supplied. The supplier was taken aback in the sense that why would you want this particular offer? Because we've discussed it, I've given you the reasons, etc. And then he indicated to me, I don't quite know why you wanted, what exactly you're looking for. Can I send you something as a draft so that I can understand, is this what you're looking for? And which is what he did.
And did that include the request for prepayment and the reasons for the request?
It was a request for the prepayment, but not the reasons for the request.
Yes.
Yes.
Okay, so you had to rely on your recollection of what Mr. Nath had said to you verbally in terms of the reasons when you prepared the written submission to the BTC.
Yes, so I relied on what Mr. Nath had said. I relied on what Ms. Daniels provided, and I also relied on information that I received from Mr. Mabilani on the submission, yes.
Okay, all right, Mr. Seleka.
Thank you, Chair. Yes, Dr. Nteta, indeed, those questions were going to come from me. But that's the difficulty I should express to you I have with the reason. Because we don't see you communicating the reason or the motivation for the prepayment to Ms. Daniels. And let me just, for the purpose of the chairperson, outline this. Remember, you write in your affidavit that the last approach made to you is on the 8th of April, 2016. This is on Friday. Now, we don't know exactly when on that day were you approached. We don't know exactly, sorry, if you're not, you probably need to speak out.
Just articulate your response, because if you nod, that doesn't get captured by the record.
Okay, maybe I can't recall why I was nodding. Maybe it was for the last discussion on the 8th. I can't remember when I nodded.
Okay.
Sorry.
So
Yeah.
I'm saying you apparently you were last approached either telephonically or in person by Mr. Nath on the 8th of April, 2016.
Yes,
This was on a Friday.
yes, yes.
Shall I assume that you are at work at this time?
Yes.
When do you start to draft the submission?
I don't recall exactly when I started to draft the submission. It could have been on the 8th, it could have been on the 7th. I really can't recall the exact day when I started. It could have been on the 9th. I do know that I worked on that submission over the weekend.
Yes, so the 8th is a Friday. The next day is a Saturday, that's the 9th. The first communication we see between you and Ms. Daniels is on Sunday, the 10th of April. remember to say yes or no.
Sorry, yes, Sunday the 10th, sorry. Sorry.
Yes. The first communication we see between you and Ms. Daniels is on the 10th, which is on Sunday. And
Correct.
that chairperson is on page 199. Oh, I beg your pardon. 199 is a reply to you. 189 is your email to Ms. Daniels. 189. I beg your pardon. But you will recall this, you will stop me because I'm giving the page numbers for the purposes of the chairperson. Because, Chair, I see we're going to run out of our estimation.
Yes. But how far are you from?
We're very far from this.
Eh?
We're
very far.
We're still a while. We're still a while, Chair.
Is that so?
Dr. Nteta can confirm that.
Well, if that,
Unfortunately.
yeah,
Unfortunately, yeah.
if that is so, maybe we should do what one would have liked to avoid. Maybe we should stop with Dr. Nteta because arranging for her to finish might not be a problem, even maybe on short notice, I'm not sure. I assume that it's not more than an hour that you might need.
Yeah.
You think it might be more?
It
Okay,
might.
but not more than 2 hours?
Not more than 2 hours.
Yeah, okay. So that we could easily fit that into an evening
Session.
session. So I think that's what we should do. Then we can release her on that understanding that we are going to arrange a date when probably in the evening we can slot her in one of these days before the end of next week. I would hope, and then try and finish. Dr. Nteta, obviously you can hear what I am saying. Would you have any problem if we make arrangements along those lines?
Chair, I don't have a problem, but I must say a note to self, next time I must get a lawyer because I think I'm being deprioritized because I don't have a lawyer.
No, Dr. Nteta, even if you had a lawyer, the same consideration could come up. Okay, so I think we are going to release you, but I'm asking Mr. Selega and his team that they be in touch with you and they will talk to me with a view that we find an evening between now and the end of next week, if possible, when you can come in maybe at 4 o'clock or 5 o'clock, and then we try and finish. But obviously, if there is a day when you can come in during the day, that will be explored as well. But because it's going to be short notice, it's something that will be discussed with you to make sure that you are available.
Noted.
All right. Okay, all right. So I think let's release her on that basis.
Yes, Chair.
Yeah.
Chair, can I?
Yes. Thank you very much, Dr. Nteta. Then an arrangement will be made for you to complete your evidence in due course. Thank you very much for making yourself available.
Thank you. I don't know the protocols. Do I just hang up or do I have to wait for you to leave the room, sir?
Mr. Selega and his team will need to make some arrangements for the next witness. So after I've adjourned, then you can disappear from the screen in a manner that has been agreed between you and the technical team. We'll then take a 10 minutes adjournment. Will 10 minutes be enough?
It will be enough, Chair.
Okay, we adjourn.
Thank you.
you ready, Mr. Seleka?
Yes, Chairperson. I am.
Yes. Yes, Mr. Berry?
I'm afraid that there are again some issues of housekeeping that we need to refer to. In that regard, Chair, if I may hand up to you a letter or copy of a letter that we received from Mr. Seleka. It's dated the 22nd of December of 2020. And there are certain aspects of this letter that we need clarity on. The first issue on which we need clarity is whether you are aware of this letter.
I have not seen the letter, but Mr. Seleka did mention that there was a response to your side.
Yes.
And I did, I think when you were here last time, I did ask my registrar to give a copy of the letter that you gave me.
Now
I
that
think in
was
terms
long-
of PAYA
That was on the third.
to the secretary of the commission
That was
to
on.
discuss with me. I have made inquiries recently, and it seems that the secretary himself might not have done much about it at the last time I had. And he is supposed to see me about it so that I understand what's going on.
Yes, just if we can just go back into the history. What this relates to is a letter that was written on the 3rd of this. It was actually incorrectly dated the 3rd of December. It was actually delivered on the 2nd of December, and it was addressed to you in your capacity as the chairman of the commission, in which we raised various issues. And then during the course of the testimony of Mr. Coco on that day, various issues were raised, some which also were covered by the letter. And what you, Mr. Chairman, stated is that if there is any information that can be made available to the Commission regarding potential corruption or malfeasance in ESCOM, then that should be made available by way of a written statement. And you will then recall that what happened then was that such a, in the form of a supplementary affidavit, was prepared, which was then made available to the Commission on the 11th of December when we appeared before you, you will recall, in the evening. And what is relevant now in this letter is that, and I want to refer you, the letter has a particularly objectionable tone, but we do not want to raise that with you at this time. But what we do need to raise with you, and if you can possibly turn to page 4 of the letter, it is issued by Mr. Seleka, and it states on behalf of the Commission. It is on that basis that we assume that it carries your authority. And that is what the first point of clarity that
it would simply
require.
it would simply be a response of the legal team as represented by Mr. Seleka, the legal team of the commission. It wouldn't necessarily be my response. It would be a response of the legal team of the commission.
Well, then
Yeah.
you know, as I said, it was issued on your behalf.
No,
And
no, no,
on
no,
that
no.
basis, we take it at face value.
Well, what is the issue on page 4? Just talk to me about that.
Yes. We want to refer you to paragraph 7, 8, and 9 in the letter, where it is stated, you will recall that in the letter, which you informed us on the 11th that you had read, my client made various, on his behalf, his attorney, speaking on his behalf, averred that there were instances of corruption and malfeasance and irregularity in ESCOM that are apparently not being investigated by the Commission. And you, on that day, on the record, said that, well, if Mr. Coco has information in that regard, shouldn't be put forward in terms of a letter, but the information should be provided to the Commission by way of a formal statement, which was then done at a later time by way of the affidavit. But what is stated in paragraph 7, and you will recall that there were various issues, the one relating to the preferential treatment that Glencore has received in the past and still receives at the hands of ESCOM. The second related to bribery and corruption of a company called Just Coal, a supplier to ESCOM, which has been admitted by its managing director publicly and before the Parliamentary Select Committee. And then there are the matters of Sumitomo, and then the matter of the contract at Medupi relating to Mr. Masangu. So what paragraph 7 in the letter states is as follows. It says, what you have stated in your letter regarding Glencore is once again evidentiary material already contained in affidavits of witnesses before the Commission, including one of your client's affidavit. Well, we are only aware of one affidavit, and presumably Mr. Seleka is referring to that on your behalf. It is not for the Commission to comment on such matters in correspondence. However, insofar as your client alleges preferential treatment of coal suppliers in the Glencore stable, your client is at liberty to provide the Commission with information to substantiate these allegations, which has been done. And then it goes on, and to demonstrate its relevance to the Commission's terms of reference. Now, that is the issue that we need to inquire about, is because that was not when you addressed us and Mr. Coco in that regard on the 3rd of December. That was not stated by you as it were a precondition. I would think for...
I'm sorry. Are you saying that Mr. Seleka says, please show us the relevance of the information or documents you are asking for, and you are saying that was not an issue?
That was not something, and we would think that is for obvious reasons, because it would be for the Commission to investigate allegations and eventually to come up with an answer to the question whether, in terms of the terms of reference, this is something that requires to be addressed in the Commission's final report. It is obviously not something that the Commission can address until an investigation has taken place. So what we need to require to know is this now what is a requirement before the Commission? Is that people who have information to supply to the Commission?
Well, certainly, if people supply information that they believe is relevant to the work of the Commission, we can't spend a lot of time looking into that unless we are satisfied that it's relevant.
Yes.
So relevance is important, otherwise we don't want to be spending hours and hours on something that may not be relevant.
But with respect, you set that out very, very correctly, and that it is for the Commission to assess the relevance.
Yes,
for the Commission to look at the information that is provided and to decide whether that information should be further investigated.
Yes, but
whether it warrants investigation.
Yes, but what I'm saying is, I would see nothing wrong if the legal team says, please tell us what the relevance of this information is.
So it must be assumed now that...
In other words, before they might take a view that is not relevant or they can't see the relevance. But you, the person who has submitted the information, might have a certain perspective and might think it's relevant. So when you respond to the legal team, you say, as far as I'm concerned, this is the relevance.
Yes, but that is
and maybe they get persuaded, maybe they don't get persuaded.
Yes, I again would say that the legal team is not the commission, sir. You
No,
are
the
you are
legal
commission.
team is there to assist
Very well.
to assist me, and they have a role to play, and they play a very important role. So if certain things need to go to them first because they bring them to me, and they know some of the issues that I will raise. And in order to make sure that when they bring those things to me, the matters are ripe, they would explore those things because obviously they know, they'll say, what's the relevance of this? Sometimes it's relevant but not so important, that kind of thing.
Now, if we then go on to paragraph 8, and that refers to the entity Just Coal Pty Limited, in which Mr. Coco, in his supplementary affidavit, gave detailed information, also of the fact that the managing director or CEO of that company admitted bribery and corruption and the bribery of ESCOM officials. But we nevertheless receive a letter from the Commission stating that we have to provide that it is relevant in terms of the terms of reference of the Commission. While what is before you already, it is very obviously relevant to the terms of reference of the term of Commission. And we do not understand why, if obvious irregularity has been pointed out and bribery and corruption, why there is now a requirement that you did not specify on the 3rd of December that is now put forward, that not only do we need to provide information in this regard, but we need to explain the relevance to the terms of reference.
Let us deal with this matter in this way. It seems to me that I do need to have a meeting with the members of the legal team, Mr. Selega, and Mr. Selega, as well as the Secretary of the Commission, and that they should put together all the correspondence exchanged between yourself and the legal team or the Secretary and the Commission, and I get briefed fully as to where everything is. One, because I was concerned that the Secretary doesn't appear to have done much about the Paya letter. So I am going to make arrangements. Mr. Selega, I think, talk to all concerned. There may be other people other than the Secretary. There may be other people who are involved in some technical things. Let us find time before the end of this week, if possible. Maybe after the hearings.
Yes, Chair.
To have a meeting so that, with all the information, so that I can be briefed fully where the challenges may be with the request or some of the requests made by Mr. Koko's legal team.
Well,
and
this is...
after that briefing, it may be necessary to have another meeting involving Mr. Berry. It might not be necessary depending on what the briefing will be.
Yes, Chair.
But I would like this matter to be finalized as soon as possible.
Mr. Chairman, the issue is really that you gave us certain directives regarding what we should do to bring these allegations to your attention, which we have done. Now, if you go on to paragraph 9 of this letter, it states as follows. The Commission is not investigating the matter of Sumitomo. That relates, as you will remember, of Mr. Tsotsi having written unlawful a letter to Sumitomo to undertake that for certain transformers that weren't ordered, payment would be made. Now, the statement is simply that the Commission is not investigating the Sumitomo matter, and the clarity that we require from you, sir, is that correct?
Well, we are going to have a meeting. I know that whether it's Medupi or Kusidi, I know that there was a time when I was approached about whether there should be any investigation, and I said, we can't start a new investigation. We don't have the time. In regard to whether it was both or one of those, certainly I've made that decision. But Mr. Berry, there is no need to continue to discuss this now. I'm going to have a meeting before the end of the week with the relevant members of the legal team of the Commission who are involved in this matter, and the Secretary of the Commission, and other people within the Commission who might be relevant. I will have all the correspondence before me that has been exchanged. I will check what challenges there are, and after that, I will have taken a view on the matter, and either you will then be informed, or I might need to have a meeting that would involve your side before there is any finality.
Yes.
But I think we must leave the matter at that.
There's just one further issue in this regard that I do need to point out. And it is, as you have indicated, that you rely heavily on the legal team. So this is representative, at least of the legal teams, albeit that it's issued on behalf of the Commission. But in paragraph 9, it goes on to say that the Commission does not have the time and capacity to investigate the Kusili and Medupi matters. That is understandable, albeit that it is within your terms of reference. But it then says, it goes on to say, it has taken a decision to confine itself primarily to matters identified in the Public Protector's report. Now, is that correct?
Yes, it is correct that already last year, not even last year, 2019, in the extension application that was filed in the High Court, I made it clear that in order for the Commission to finish its work within the time that I asked for, it would have to confine itself within the issues that are identified in the Public Protector's report. But I did say that those matters that fell outside of the Public Protector's issues, but within the terms of reference of the Commission, that the Commission had already started, we would try and finish. And that if any matter that we had not started was brought to my attention, which I thought in my own discretion was particularly important, then I could make a decision to say we look into that. So that's in the High Court papers already.
Very well. So it does not imply a limitation of to be published or otherwise of the terms of reference.
Sorry?
It does not imply a limitation of the terms of reference to be published in terms of the Commissions Act in due course.
What?
It does not imply, or in any other manner, some limitation on the terms of reference.
If you go and read what is said in the affidavit, is that the Commission would either ask the President to amend the terms of reference, or the Commission would make a recommendation that other matters that it could not deal with because of the constraints on time be dealt with by law enforcement agencies or by some other forum. So that's what is said. Because otherwise, if we were going to investigate everything that is covered by the terms of reference, we would sit here for 10 years.
It says an indictment of the state of affairs.
Yeah,
but,
because you
we
see
have-
the terms
we
of,
obviously have an understanding.
you see the terms of the reference contemplate us looking at every municipality in the whole country, looking at every national department, looking at every provincial department, looking at every SOE. It's just too wide.
And insofar as you are unable to do that, no doubt it will be covered by the recommendations that the Commission will in due course make.
Sorry?
I say that insofar as you are unable to deal with all those matters, then I would assume it would be dealt with in the recommendations that the Commission will make in relation to other matters that have come to the Commission's attention.
Yes,
but
that
the
was-
Commission
what-
has been unable to.
What I said in the extension papers is that either we'll ask the President to amend the terms of reference, or we'll ask that those matters that we are not able to deal with be referred to some other forum or law enforcement agency.
I then want to go to a second matter of housekeeping, and that relates to the request in terms of the Promotion of Access to Information Act. You will recall that on the prior occasion, on the 11th of December, we handed a copy of that personally to you, but the original thereof had been delivered to the Commission some days earlier. Now, in terms of the Act, that had to have been responded to within 30 days. And if it is not responded to, then it is regarded as a refusal of the request. Now, we obviously have understanding that there were holidays and et cetera in the intervening period of time.
Yeah.
But the question that now arises is whether we should regard the fact that the notice in terms of the Promotion of Access to Information Act, or the request in terms thereof, has not yet responded to, is whether we should regard it as a refusal. And unfortunately, here you are the information officer.
Well, I've just
Whether we
said...
should regard it as a refusal of that request.
Well, I've just said to you that I made inquiries recently with the Secretary, and I established that not much had been done. And I've said that I'm going to have a meeting involving the Secretary and the legal team and everyone concerned to look at all these requests that you have made, and that includes that one. And I've said that after that, I will be able to take a decision. Either the decision will be taken without any further meeting with you, or I might decide that before a final decision is made, there should be a meeting involving your side. But that's a decision. Which one it will be is something that I will take a view on once I've had a full briefing as to what challenges, if any, there are in granting the request that you have made, giving you the information that you request.
Yes, Chairman, but Chairman, the issue is then that, as I understand what you're putting across to me, is that despite the provisions of the Act, we should not regard the fact that the document has not yet been responded to as a refusal of the request.
No, definitely at this stage, I've not taken a view that you should not be given the information. On the contrary, my inclination is that the Commission should give you as much information as possible that you are entitled to, or if there are grounds not to give you certain information, that should be raised with you, and let's hear what you have to say. So certainly there is no attitude to say in a blanket way, you should not receive anything. Certainly, I want to be briefed fully about what has been exchanged between your side and the legal team and the Secretary, and what the Secretary's attitude is, and other units of the Commission. And then after that, we can take it from there.
Yeah, Mr. Mr. Chairman, the prior request is a request that stands on its own legs in terms of the legislation.
But I've said that I want in that meeting to discuss that plus this and all the requests that you have made to the commission. I want to put finality to this.
Chairman, with respect, on each occasion that we have prepared, that we have appeared before you, you have expressed the sentiment that you have just expressed again. And our attempts to get hold of the documents, even by the issuing of a request in terms of prior, have met with no success. And the question is now, how long is it going to take?
Well, I've just
Because
told you,
the
Mr.
Act-
Berry.
The limit that the Act
Mr.
provides
Berry,
has already been
Mr. Berry,
exceeded.
what I've told you is two things. One, I want a meeting with relevant people within the commission to be briefed fully about what is the problem, are there any challenges, both in terms of the prior request and in terms of this. Two, I've said to you, that meeting is going to be, I want that meeting to be before the end of the week. And I've said, after that, you will be contacted. Whether you are contacted to say, let's have a meeting, or to say, this is the final position. That's what I've told you. Now, I don't know what it is that you don't understand when it will take place.
Well, it's a question of when is the Commission now going to ask for an extension?
Sorry?
Is the Commission going to ask for an extension of the time period provided for in the Act?
Well, leave that to us. I've told you what's going to happen within this week.
Very well.
Yeah.
Very well. I hear that. And this, on the third point of housekeeping, the roof leaks. And it drips water on these benches.
Thank you,
I'm not
Mr.
sure
Berry.
that you're aware of it, but
Thank you, Mr. Berry. Mr. Selega, I want us to continue.
Yes.
I see Mr. Koko raises his hand. Mr. Koko, good afternoon. Your counsel was speaking to me just now, and I think when your counsel was speaking, you were speaking to me through him.
I understood, Chair, but I'm bending in my chest.
Okay.
So I'm bending in my chest, and
Shall I give you 1 minute?
please give me 1 minute.
Okay, 1 minute.
When we came here, people accused me of meeting people anywhere else.
People accused you of?
Accused me of meeting people in dark corners, including Melrose Arch.
Oh, okay.
Telephone records are very important to prove who is where. I've made this commitment to the commission that I will give relevant telephone records to the commission. I've done that. I may have done that late, but I've done that.
Yes, yes.
But I get a letter, paragraph 6 on your letter, that says,
This letter?
yes,
Yeah.
5 or 6, that says, Mr. Koko, we don't have telephone records of anybody. Now, the chairman said when I was last here, is that when you have records, we have no reason to keep them from you. But when I get a letter from the commission that says we don't have these records, when I know you have them, it borders on a trust relationship. So Mr. Seleka says to Ms. Daniels on the 15th of September, day 67, he says, but you know, we have obtained telephone records between you and Mr. Koko, in which we see that there is a telephone call from him to you the evening before, the night before, 3 minutes before the evening.
Yes.
My telephone records show me that this telephone call that Mr. Seleka is talking about here is factual. It's factual.
Yeah.
For Mr. Seleka to then write back to me and say, I don't have telephone records of anybody, when I know he has them,
Yes, yes.
it's a trust issue.
Yeah.
It bends
Yeah.
me.
Okay.
It
No, I
further-
understand what
it
you're
further
saying.
supports what I've been saying to you all along, that the only reason these telephone records are not coming out is because they are not telling you the story they want you to believe. That's the only reason. I'm hurt
Yeah.
that the legal team writes to me to tell me What, in the township, I would say it's a lie. But I would not say it in this area.
May I?
These things should be sorted out.
Yes, Chair.
We shouldn't really be taking so long about some of these things.
Yes, Chair.
Now, I do know that one of the witnesses, I don't know if it was Ms. Daniels or, I do know that one of the
Veleti.
witnesses was referred to cell phone records.
Yes, Chair.
Why are those not given to Mr. Koko?
Chair, they should read the letter to you in totality. Because the letter says the telephone records of the witness that were referred to here is the one of Ms. Nonkululeko Veleti. That has been conveyed on more than one occasions. It's repeated here because my telephone conversation with Mr. Koko Satini, he says we must give them the telephone records that were referred by the witnesses before the commission. And I say then, with that definition in mind, the answer is the only person who has not only made reference to the telephone records, but also undertook, before that, Chairperson, paragraphs 5, Ms. Nonkululeko Veleti is the one who referred, and that has been conveyed to you in a letter, and the records were again provided to you. So that is done. Now, and these issues can be dealt with in chambers, so they can be dealt with us telephonically by virtual meeting, that also on such and such a date, you referred Mr. Daniel to telephone records. She didn't provide us with telephone records. Then we can go to the transcript and say, okay, here it is. Let's see what we can provide them in regard to that. But the request has been blanket and general, at least specified insofar as the witness is
Well,
concerned.
what you would know, of course, is what telephone records you have that
Yes.
relate to certain witnesses, which relate to conversations or alleged conversations with Mr. Koko.
Yeah.
Why don't you just give him all of those, irrespective of how the request has been formulated by his lawyer? To say, you know that Ms. So-and-so and so-and-so and so-and-so, we've got telephone records which connect or are connected or allegedly connected with conversations with Mr. Koko, and say, here are all of the telephone records that we have where one or other of the following witnesses seems to have had a conversation with you. Here they are. What we have given you is everything we have, as long as it's a telephone record that allegedly relates to a conversation that you had with somebody who has given evidence in the commission. And say, here they are.
Yes. Chairperson, since the PIA request,
Yeah.
I have done that exercise with the relevant persons.
Yes.
After the December holidays,
Yeah.
I had meetings with them. We have made some progress in regard to that.
Yeah.
So the chairperson, consistent with the meeting that the chairperson has in mind,
Yeah.
you will then get the latest
Yeah.
in regard to what is happening now.
Yeah.
And the request regarding PIA can be provided, because I didn't personally also have knowledge of how much does the forensic investigation team has in regard to that information.
Yeah. Well, what you can do is to say, as far as us as the legal team leading evidence in regard to ESCOM,
Yes.
as far as we are concerned, these are the records we are aware of, telephone records that we are aware of that relate to your conversations with some of the following people or the following people. When what we are giving you is all that this legal team is aware of.
Correct, Chair.
Yeah,
Correct.
okay, all
We can
right.
certainly do that.
Chairman, it is for that very reason why the prior request was delivered. It's because it was averred that my attorney had in some way or another limited the very, very detailed requests that had been made in prior correspondence. So the prior request has to be responded to in terms of the Act.
Yeah.
And that means we're asking for all those records if they are in the Commission's possession. It's not a
Yeah.
question of relevance. We don't have to provide a reason why we need those records.
Well,
We're asking them in terms of that
well,
Act.
let's
And if
stop,
they are in the
let's
Commission's
stop the
possession,
conversation now, Mr. Perry. I've indicated what my attitude is. But anything that can be finished to Mr. Koko's legal team without having to wait for the meeting that's going to happen should be finished. And then, of course, there will be the meeting. Okay, all right.
Thank you.
Please, let's continue.
Thank you.
I think just administer the oath again because we have had quite some time lapse.
Please state your full names for the record.
Machela Moses Koko.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence will give will be the truth, the whole truth and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
We may
Yes,
Proceed. Thank you. Thank you, Chairperson.
Mr. Selega, you might just in a few minutes or a few sentences just tell the public what Mr. Koko's evidence will be about today so they can follow easily.
Thank you, Chairperson. Mr. Koko has appeared before the Commission previously. He's appeared on 2 occasions. He was called to deal with matters pertaining to the suspensions of the 4 executives. That was the first part of his appearances. This second part of his appearance relates to matters of what we have called, for ease of reference, the transactions. They primarily relate to the transactions done between Eskom and a company called Tigeta. And along with those transactions, what was happening simultaneously in regard to other entities, in this case, such as Glencore, Optimum, entities such as Zaro, and we will also look at matters pertaining to Trillion and McKinsey to the extent that we do not traverse issues that have already been done at court, Chairperson. So in regard to the transaction matters, Mr. Koko has prepared an affidavit and it deals with the prepayment or prepayment decision of 1.68 billion. Yes. And then the process in regard to that, the motivation for that, he will deal with that because Mr. Koko signed the submission that was submitted to the board to make the decision for that prepayment. There is the build-up to that prepayment also, Chairperson, is the interactions between Eskom in the acquisition of Optimum, the interactions with Tigeta, with Optimum, with the DMR. Mr. Koko will deal with that. He will also testify then on the prepayment we were busy dealing with Dr. Nteta, which comes in the following year, April 2016. Mr. Koko also signed a submission in regard to that prepayment. we expect that he will explain the details of it, the rationale, and ultimately the penalties that were pursued against Optimum. Mr. Koko, then there will be a few questions from my side arising from matters testified previously. I just want to tidy up the loose ends before I go into the transactions. Now, Chairperson, I'm mindful of the time because I suppose we will have to stop still at the time agreed with Mr. Koko's counsel.
Yes.
Even though 40 minutes was taken
Yes,
in dealing with preliminary issues.
yeah.
Yes. Further on housekeeping, Chairperson, we have the bundles. For the purposes of the record, we have ESCOM bundle 15. That bundle, Chairperson, has been updated, so it will be
There is 15A here.
15A and 15B.
Oh, it's, yeah, 15A and 15B.
So that contains Mr. Koko's affidavits with the annexures,
Okay.
and it has been updated with other material relating to Mr. Koko. Then we will use the reference bundle, ESCOM bundle 18. So there's also A and B in that reference bundle. 18, A and B.
Are we going to need it later or now?
No, I'm not starting with it now, Chair.
Yeah.
I may in the process, yes.
keep it there,
We can
yeah.
just have it handy.
Okay.
Thank you. Mr. Koko, a couple of matters then arising from your appearance previously. I want to just start with that and finish it off. You testified on one of the two occasions when we were dealing with the suspensions that Ms. Daniels and Mr. Masango testified at the Parliamentary Portfolio Committee that they acted together to get rid of you. And this was in response to the chairperson asking you about why would they have, on the 10th of March 2015, communicated to other persons the same information or similar information. You explain and explain, but ultimately came to this. Chair, I can tell you this is what they testified at the Parliamentary Portfolio Committee, that they acted together to get rid of me. You remember that?
Yes.
But I have seen in your letter, which my learned friend said is incorrectly dated the 3rd, because it was delivered on the 2nd of December 2020, that in a paragraph, and I will read paragraph 71, you read there, Mr. Masango also told the
Paragraph
parliamentary...
71 of his affidavit, or paragraph 71 of what?
It's a letter from his attorney chairperson.
The one that is dated the 3rd, but it's actually the 2nd one. The
Yes,
one
that's
that
right.
Mario referred to.
You have a... Chair, I think I will have a copy for the chairperson. I will presume that my learned friend has a copy.
Well, just maybe
Read
if
the
you
letter.
read it aloud, maybe.
Yes.
But arrangements should be made for me to have a
Yes,
copy.
Chair. Thank you. So he says, Mr. Masango also told the Parliamentary Portfolio Committee that he worked extremely hard with Ms. Daniels and unnamed journalists to get Mr. Koko out of ESCOM. This occurred after Mr. Koko had removed Mr. Masango from his position as ESCOM's group executive, group capital, i.e. the ESCOM division responsible for new capital projects, including the massive Medupi Kusile projects. That's all in brackets. And then you say, in January 2017, because of his involvement in corruption. So the collaboration between the two of them, you are saying, it happened after you removed Mr. Masango from his position in January 2017 because of his involvement in corruption. That's what is stated in that paragraph.
That's correct. The collaboration between the two, and the two of them have never made a secret, Chair.
Yes.
So, I'm sorry, Mr. Koko. I don't know whether it's the ECON. Yeah, I think they need to adjust it. Mr. Koko, please just repeat what you said because
I'm
I
saying
didn't hear.
that is correct. The collaboration between the two of them have never made it secret.
I've never made it.
Secret.
What is it that they never made it a secret?
The collaboration
To have you removed?
to have me removed.
Okay,
They've never made it secret,
is that so?
independently and collectively.
Yes. And this is after a certain date or month in 2017?
Certainly.
Okay, all right. Yes, Mr. Silega?
Chairperson, thank you. Just for the benefit of the chairperson, I want to hand up to the chairperson a copy of that letter.
Well, you are not watching now. Yes.
Yes, the letter doesn't seem to be paginated, Chair, but the paragraphs are numbered. I was reading from paragraph 71.
Yes.
Paragraph 71.
Yes.
Yeah. Yes, Mr. Koko, but that doesn't seem to be an answer to the chairperson's question, which he was specifically asking in relation to 10 March 2015. Because if, on your version, the collaboration started after you removed Mr. Masango in January 2017, that means that collaboration would have only started nearly 2 years after the suspension of the executives.
I have no doubt that's the case.
Thank you. Then there was, again, your statement made when you were testifying that in 2015, when we're talking about Mr. Salim Essa, Mr. Salim Essa, that in 2015, you didn't know Mr. Salim Essa.
That's correct.
But if you go to, in fact, it starts with your disciplinary hearing. I will go to the emails. Remember charge 1 of your disciplinary hearing related to emails you exchanged with businessmen.
That's correct.
And that was from July 2015, shortly after you came back from your suspension,
It was from July 20, 2015.
2015. And those exchanges, they go all the way, at least in 2015, to December 2015. There are correspondence after in 2016.
That sounds correct.
Yes. Chairperson, they are in the reference bundle, just for the chairperson's ease of reference. Page 10, 18B. Reference bundle 18. Does Mr. Koko has
18B,
18B?
okay. And what page? Have you got the page?
Page 1018. 1018.
1018.
1018.
18B.
18B, yes.
Okay.
Page?
1018. 1018. But Chair, I'm doing just for your benefit because Mr. Koko
Yes,
does.
yes, no, that's fine.
Yes.
Yes.
Otherwise, I
continue-
could move
Continue.
a little faster. So you will see the email. In fact, the one is on the 20th of July. The first one is on the 20th of July. That's on the day of your return from suspension. Are you on that page?
Just give me
Remember, we followed the
yeah,
black?
the black ones.
Yes. 1018, 1018.
1080.
18, 1018.
1018. Yes.
So that's the first email from Marcella Coco double M at ESCOM, Monday, 20 July 2015, 7:56. And the email is addressed to infoportal1@zoho.com, internal consulting directive. Print this, you say. Now, those emails, Chairperson, they go on, and I will ask Mr. Koko, let me just go through the emails quickly. The email has an attachment, which is the document they attached, which is a ESCOM document, Directive for Implementation of National Treasury Cost Containment Instruction. Chairperson, then you go to page 1032. It's another email on the same date to infoportal1@zoho.com, also from Mr. Marcella Koko. The subject is top engineers. And then you have an attachment on the next page, approval conditions agreed between acting CFO and acting GC&T on Friday, 26 June 2015. Then there's a spelling error, it seems there. Top Engineers Development Program. You see that, Mr. Koko? I'll just give you the page numbers quickly. I will expedite this. Then on page 1035, 1035, there's another email on the same date, 20 July 2015, from Marcella Koko to InfoPortal1. The subject is ESCO resolution, and the message is print this 1-2. It's a round robin resolution, date 5 March 2014. The next email is on page 1056. Also sent from yourself, cocomm@escom.co.za. This one is sent on Saturday, 8 August 2015 at 22:20 at night, also to the same email address, infoportal1@zoho.com. The subject is online vending. And it's the message. Now, these emails, so far, they don't identify the person. There's no dear Paul or dear Miss so-and-so. It's just a message you see. Print this. And this one simply says, we did not finish our discussions about this transaction. This is what is going to board, meaning to the board, of 18 August. I suppose 2015, the date is not indicated there. Would it be 2015, Mr. Coker? The date for that 18 August?
What is the question?
The 18 August, Chair, doesn't have a year number, so I'm just asking whether will that be 2015?
Which one is the 81?
The page 1056. 1056.
I'm sure it is 2015.
I'm sure it's 2015.
Yeah.
Thank you. Then the document is attached, Chairperson. Submission document, executive summary. This is a ESCOM document. And the next email, Chairperson, you found on page 1075. This one is sent on Monday, 21 September 2015 at 16:32, also from Mr. Koko to infoportal1@zoho.com. The subject is me, M-E, and the message is simply RE, R-E. Nothing further. There's a document there attached of 31 August 2015, which pertains to Mr. Petler. I think Mr. Petler was being suspended or given a notice of intention, rather, to suspend. Do you recall that document, Mr. Kogo?
Yes, I do.
Then there is, on page 1078, an email from Mr. Koko on Wednesday, 30 September 2015, also sent to infoportal1@zoho.com. The subject is simply RE, R-E, there's no message in that email. There's an attachment of a letter addressed to Minister Lynn Brown by Dr. Ngubane. Suspension of contact in any form whatsoever and or commercial relationship with the Mail and Guardian, City Press, and Sunday Times. Chairperson, you will recall when Ms. Daniels was here, there was a document, a round robin, meant to be a round robin resolution of, amongst others, ESCOM, Denel, and I can't recall whether Transnet was part of it, that, Dr. Ngubane also testified about. It came from businessmen, went into ESCOM, and it was asking ESCOM to take a resolution to terminate any contact with these media houses. Were you aware of that communication, Mr. Koko?
Was I aware of?
That communication that came from businessmen to Dr. Ngubane and asking that the resolution be taken by the board exactly on that subject line we see in this letter.
Chairman, I have listened to the evidence before this commission, so I am aware of what the discussion of Mr. Seleka is saying.
But is your awareness based on what you had in terms of evidence, or you were aware at some stage during 2015 or?
Not at all. It came to my attention arising out of the evidence in this committee. I knew of this, and at your own time, I can go into the discussions around.
You can deal with it,
But I only came aware of the information Mr. Sidika is talking about.
Yeah,
Through this commission.
Okay. We'll come to it. Then you have the email on the next page, page 1080, which is also from you, sent on Saturday, 14 November 2015 at 10:36 to Info Portal. Again, the subject is simply RE, no message, and it attaches electricity load shedding review and way forward document. You were aware of this document as well.
I'm aware of this document.
Then the next page is 1084. Again from yourself, ESCOM, Coco MM at ESCOM, Wednesday, 25 November 2015 to Info Portal. One at Zoho, the subject is simply really no subject. The message is give the boss, please. So that's the message. We don't know who is being asked to give the boss, please.
I'm aware of this.
You're aware of that?
Yes.
Yeah. And I think the last two emails, if you turn to page 1087, page 1087, I think there's an email missing in November. Two emails, but let me look at this one at 1087. So that's an email, the bottom email is from businessman, and we know businessman from the evidence is the same Info Portal address. It's dated 10 December 2015. That date is significant because it coincides with other issues. And it's sent to Machela 2010, subject two-pager between Tigeta and ESCOM, salient points, and the salient points are set out there. And we will come to it in due course, this email. And at the top of it seems to be you, Machela 2010, at Yahoo on Thursday, the same date, 10 December 2015, forwarding the two-pager to Miss Suzanne Daniels. You see that?
Yes, sir.
She's already testified about you would have seen during her testimony.
Certainly.
Then on the next page, page 1088, there is an email exchanged at the middle of the page. Yeah, but these are 2016 emails. They are not relevant for present purposes. So that's the 2015 exchange of emails, which starting on page 1018. 1018. Mr. Koko, it was established at the disciplinary hearing of Mr. Suzanne Daniels. She has testified here about this Info Portal email address. She's not finished yet. I should emphasize, she's not finished. That this email address belonged to Mr. Salim Essa. Your comment?
Testified by who?
I'm saying it was established at the disciplinary hearing of Ms. Daniels that this email of infoportal1@zoho.com belongs to Mr. Salim Essa.
Chairman, I note that. I'm shocked, I'm flabbergasted, and it angers me, if that is indeed the case. I received this WhatsApp email address from after my suspension of 2015 from Ms. Daniels. And Ms. Daniels, I met him, I was unsuspended on the 16th of July. I met her before the 20th. And before my suspension, she was my assistant. And overnight, out of the blue, she was in the chairman's office. When I was unsuspended, I had discussions with her because I was concerned about how I ended up.
When your suspension was lifted?
I beg your pardon?
When your suspension was lifted?
Yes, I beg your pardon. When my suspension was uplifted, I met with her. And we discussed how to work around the new board, around the new chairperson, given my previous experiences with the chairman, because I still today am of the firm view that I was suspended because of my relationship with Mr. Zolatsosi. Ms. Daniels gave me the email address and say, you need to keep the chairman informed. And we need to have three-way meetings as often as possible so that they are not blindsided, so that they are properly informed. And the problem with you, Mr. Koko, is that you tend to make up your mind and move on your own and isolate the board and the chairperson. So this email is for in her view, the chairman uses this email. So if you've got information.
The chairman at that time being a reference to?
Dr. Ngubane.
Dr. Ngubane, okay.
Yes, and if you have information that you think that the board Mr. Ngubane thinks differently, send it. I will print it out and I will arrange a three-way meeting between yourself, myself, and Dr. Ngubane. That will clear a lot of the problems in terms of communication. And Chairman, without fail, and I certainly wish that we can go one by one with these emails, and I can talk you through why I thought at that point it's important to bring them to the chairman. We had a meeting. The way it works at that level is that the chairman hardly uses his computer. I'm sure he does. I mean, he's a doctor. But most of the time, when you send the documents to him, the assistant prints them out and then arranges a meeting. And then when you walk into the chairman's office for the meeting, you find the documents are already set. I suspect they have a pre-briefing before you come in. And this is a document Mr. Koko wants to discuss with you. And then sometimes I would have discussed it previously with her, or I will then get into the details with it. So without fail, these documents, after I sent them to businessmen, found their way to a three-way meeting between me, Dr. Ngubane, and Ms. Daniels. If it turns out that somebody else, Mr. Issa, owns the email address or uses the email address, it makes me angry.
Sorry, what's the last word you said?
It makes me angry.
It makes you angry. Okay.
Well, let me say, Mr. Koko, To the extent that you may deem it necessary that we go through those emails one by one, that arrangements, that should be done at some stage. So you just mentioned that you wish that could be done. So I'm just saying,
I wish that could be done, but what is also important, Chair,
if it's not done now, at some
Yes,
stage it must be done so that you can deal with them properly.
yes, what makes me even more upset is having listened to to the evidence before this commission, and having read the legal team had the decency to give me the records of Ms. Daniel's testimony. I mean, Ms. Daniel says, my legal team and outer did extensive research on the identity of the businessman email address. And it belongs to Mr. Seleka. On both occasions, both at the disciplinary hearing and here, when it was put to her that, but hang on, Mr.
Richard Seleka.
Mr. Seleka, Mr. Seleke,
That's right.
I sincerely apologize.
It's a, not a.
Mr. Seleka.
It's Seleka.
Mr.
This one is Seleka.
Yeah, so Mr. Seleke, it's not Mr. Seleke.
Yeah.
It's,
Richard Seleka.
it's not Mr. Richard Seleke because Mr. Seleke was not even in the employ of the department when this email was used. Her body language, she just became stubborn and saying, but I hear you, but you have not proven who this email belongs to. And I've read the subject matter expert or the forensic expert that imaged the computers. I mean, even though the heads of argument in the disciplinary hearing says we could not conclusively say it's Salim Issa. That's the message that comes out of the heads of argument of in the disciplinary hearing. We did not conclusively conclude that it's Salim Issa. But we've relied on the attachments that were sent on that email. And we can see that some of those documents were originated or edited by Salim Issa, and therefore, in all probabilities, it belongs to Salim Issa. Chairman, it does not matter for me whether it's Salim Issa or not. It doesn't matter. What matters to me is that if that email address belongs to an external party, then it's a serious security breach for me. That concerns me. Salim Issa is neither here nor there. But whenever I communicated on this email address, I never had the intention or the impression that there is a third party that does not belong to ESCOM that is having access of that email address.
Mr. Seleka.
Thank you, Chair. Yeah, we've got time limitations.
I'm sorry, I think we need to take a very short break.
Okay.
Yeah, just 10 minutes and then we'll resume.
Thank
We
you,
adjourn.
Chair.
Okay, let's continue.
Thank you, Chairperson. Mr. Koko, talking of the version of Dr. Ngubane and Mrs. Suzanne Daniels, you would also recall that between the two of them, the one says, the email was given to me by the other, the email address, and that the one said it is an email address that belongs to Richard Seleke of the DPE, and vice versa. So Dr. Ngubane says that's the explanation from Ms. Suzanne Daniels. Ms. Suzanne Daniels says, when he gave it to me, he gave me that explanation. You recall that as well, that evidence?
Yes, I do, Chair.
But I think when they came here, and particularly referring to Dr. Ngubane, he had to concede that that email could not belong to Mr. Richard Seleke.
I don't believe so too.
Ms. Suzanne Daniels has
What you have, the answer you have given, I guess, means you don't believe that it belonged to Mr. Richard Seleke, not that you don't believe.
I apologize.
Yeah, that's what you mean.
That's what I mean.
Yeah,
That's what I mean.
okay.
I thought I heard Mr. Koko say, I do believe that that's what he conceded.
Certainly.
Yes.
Well, no, I think he went beyond that. I think he said he also doesn't believe that it belonged to Mr. Richard Seleke.
Oh, earlier.
Yeah.
Earlier.
Well, he's stating his position. I think his position is, that is Mr. Koko. I also don't believe that it belonged to Mr. Richard
I
Seleke.
agree with what you said.
Okay.
And I'm saying over and above that,
Yes.
I do not believe that it belongs to Mr. Richard Seleke.
Okay.
Yes, yeah.
Purely based on the evidence
Yes.
I've had.
Yeah.
I don't know whether you've also looked, you're aware of the Fundutsi report, because it goes into this email of Businessman Info Portal and how CVs were exchanged with this email address to the DPE, and people should be appointed at this board and that board.
Chairman, only to the extent that I've had
Okay.
through on this commission. The Fundutsi report, I did not have sight of it because it had nothing to do with me. And what I can confirm is that I listened to the evidence, and I can confirm what Mr. Seleke is saying.
Yes. Thank you. Then the other item which you testified about, Chair, moving on. I don't know whether you have questions on the emails.
Well, do you intend dealing with them more at some other stage in terms of the individual emails?
Not really. I will have, well, there's one or two that I will go back to.
Yeah. Well, maybe let me ask this question. You must just tell me, Mr. Gogo, if I understood your evidence correctly. I understood you to say you were given this email address, info portal, is that what?
Info portal Soho 1, I think.
Yes. Now, I understood you to say you were given this email address when you came back, after you had come back from your suspension,
That's correct.
and that the person who gave it to you was Ms. Daniels.
That's correct.
And what I didn't understand quite clearly, and I would like you to deal with that again, I seemed to understand that she was saying to you, here is an email address that you and I and Dr. Ngubane can use. But I didn't understand use under what circumstances. So just tell me more about that conversation when she gave it to
No,
you.
Chair. This is the email address that is used by the chairman.
The chairman.
This is the chairman's email address.
Yes, that's what she said to
That's
you.
what she says.
Yes.
And Chair, the ESCOM security policy, is, information security, is also given to me, and the commission has it. What did not make me uncomfortable is that without fail, all board members use their private email addresses. I also used my private email address from as far as when I was still at Duva, and that is typically triggered by the servers coming down Warawara. But it was not unusual. It was not something to raise my eyebrows. Because, I mean, if you've got, I've listened to this commission, you refer to board emails left, right, and center. I don't have access of them, but I can assure you, almost most of them are on private email addresses. So there was nothing that would make me suspicious. Because first, it's not unprocedural. The company policy does not prohibit it, and the rest of the board members are using it. So I did not see anything wrong. In fact, only when the Gupta emails saga blew, then I started becoming very suspicious. In fact, worse things happened because after that, my account was shut down by Yahoo because of suspicious activities that were happening on my Yahoo email addresses, but that's too much.
So was Ms. Daniels effectively saying to you, presenting this email address to you as one of the email addresses you can use to communicate with the chairperson, or as the only email address to use? What was your understanding?
No, the chairman, the board members have got email addresses. They have email addresses. I've never sent Dr. Ngubane an email address before I was suspended. I had no reason to interact with with him. I apologize. When I came back, Ms. Daniels was very clear. He didn't say this is the email, that's a portal that 100 of us have got access to it. It was an email of Dr. Ngubane. Whether it was an email of Dr. Ngubane on the ESCOM one or on a personal one, Ms. Daniels has access to it as an assistant. So again, it was not a surprise that I will send it to it and he'll print it. My PA has the same as well. In fact, I saw one of some of the emails, I'm sure of Mr. Seleka will go to it. My PA sent it to somebody else on behalf of Mr. Koko. So you do have that. It's common within ESCOM.
Now, there is something that seems unusual with regard to the use of this email address by, I think, and Mr. Seleka will correct me if my recollection is wrong, by many, if not all, the people who seem to have used it. Namely, that there seems to be a conscious decision not to reveal the identity of the person to whom the emails are addressed when this email address is used. And on the emails to which Mr. Seleka has drawn our attention coming from you, I see that the same thing seems to happen. There seems to be no email where you address the person, dear Chairman, dear Dr. Ngubane, or anything like that. Now, it may well be that if it was just one person, and we're talking about 3 emails, that one should not make much out of it. But I just note that if I'm not mistaken, almost everyone else who has used it doesn't reveal the identity of the person they are sending the email to.
Good question. Chairman, I worked for Mr. Molefe for over 2 years. Anosh was also my senior. Mr. Singh was also my senior. I invite you investigators to go and check my communications. You have them. You've imaged my computers. See what I communicate with Mr. Molefe. I never say Mr. Molefe. I never do that.
That's quite important because it might show that's how you.
Yeah,
normally.
Even today, I don't call Mr. Molefe by his name.
Yes.
Even today, I don't call Dr. Ngubane by his name.
Yes. So, but what are you saying that your emails won't have dear chairperson, dear CEO?
No,
dear
well,
Dr.
let me say no. Let
Yeah.
me say no. That may sound stupid to say no, but I'm simply saying you'll find, by and large, if not most of them, I will either say boss, chief, or lekgowa. That's how I address.
Well, that's fine because I think in that way you are identifying the person. If you say boss or whoever, you might only be using the salutation or the name that you use to relate to that person, but at least it is there, you know. If it was Mr. Mr. Abram Masango, maybe you'd say Maki.
Yes, yeah, that's exactly.
But it's a way of
In fact, that's
addressing
how
him.
I addressed him even in writing.
Yes. So, therefore, to the extent that in emails to other people, such as maybe Dr. Ngubane or Brian Molefe, you might say, dear boss or high boss or dear chairperson or whatever, that would not say to me, that's the way you normally, that would not say you don't address the person, because as I see it, the 3 or 4 emails that Mr. Silega referred to, there is no salutation like hi chairperson or dear so and so. It's silent as to who
There's a reason for that.
are referring to.
It's all of them.
Yes, so that's the part that I'm saying, and I'm saying you are not the only one. It seems that other people who were sending emails to the same email address, it seems that they were also not addressing the person in the normal way in terms of salutation. There seems to be nothing, to say, who are you sending this to?
Chairman, I can't talk about other people.
Of course, yes.
I can't talk about other people. In fact, the more I talk about other people using this email address, I get worked up. But the emails that I send, so there's an email, for example, that says print this. That is because I knew that the recipient on that one would be Ms. Daniels, because I would have discussed it with him. It would be Ms. Daniels. We have not finished this discussion previously. So let's finish off this discussion. There's a next board meeting coming. I don't want to get to that board meeting without having discussed this, because then and it happens, Chairman, and all of them without fail, these are the emails where I think I have a serious disagreement with the chairman. All of them. And I don't want to have that disagreement playing in the public.
Yeah.
The chairman, the discussion will be there in the board, and I will say my say, but the chairman will know it's coming, and he will not feel disrespected, and he will take it in good spirit. I mean, let me give you an example. The email that bans ESCOM from advertising on Sunday, on City Press, Sunday Times, and Mail and Guardian. There's a resolution of the board. The person to give effect to that is a group executive commissioner. Who is that? That's me. But I know that it's irregular. It's irregular. The ESCOM procurement procedure, which I was a custodian of, says if you think the supplier has committed a misconduct, you don't just suspend him. There is a process you take the supplier through, and if the outcome is to stop using him, it goes through a process. But now I come in, there's a resolution of the board. Suzanne gives me a letter from addressed to the minister. I said, but Suzanne, I cannot give effect to this. I cannot. And for the record, Chair, and I listened to the evidence of Dr. Ngubane, that letter, that resolution was never implemented.
It's never?
Implemented.
Yes.
Certainly at ESCOM. Precisely because of the discussion that I had with Dr. Ngubane and Ms. Daniels. And once I talked to them, I told them, Chairman, I'm not going to break the rules. Of course, I'm polite. And Dr. Ngubane is an adult, and he's a better version of Mr. Tsotsi. And then he listened. He listened. But this is why I have a preference, God willing, that we take every single email, every single attachment, and say, did you have cause to send it to Dr. Ngubane? And what was that cause?
Yeah. Okay. I think that will need to be done next time. I think it is important that it be dealt with. Firstly, because Mr. Koko wants to show, by way of dealing with each email, that as far as he was concerned, he was communicating with Dr. Ngubane. But also, I think it's important for establishing exactly what the position was. So next time when he's back, just remember that we deal with that, yeah.
Because we will also have to get the version of Dr. Ngubane and Ms. Daniels on that explanation.
Okay. You said you were about to move to something else. Is that the case?
Yeah, it's one of the points. Yes, I was about to move to one of the other points.
Connected with the emails or not with the emails?
Connected with my tidying up of the versions Mr. Koko testified about last time.
Okay, I just want to mention this to Mr. Koko for you to comment. It's got nothing to do with the emails. You remember that in your evidence you said, and you have repeated today, that you believe that your suspension was, I don't know if orchestrated is the right word, orchestrated or instigated by Mr. Tsotsi. You remember that?
That's correct.
Yes. I recently had reason to look at the evidence of Mr. Linnell, and I saw that he said in his evidence at the Durban meeting of the 8th of March, where Mr. Tsotsi was there and Mr. Dumieni was there, he says that when the issue of the suspensions of the executives of ESCOM was raised, Mr. Tsotsi's initial position was to oppose the whole notion of the suspension of executives. And of course, what that would mean is that to the extent that what was being discussed at that time included your own suspension, it would seem, according to Mr. Linnell, that Mr. Tsotsi's initial position was to oppose the entire suspension of the executives. So I just thought it's important to mention that you might or you might not wish to comment about it.
Most certainly, I would want to comment, Chair.
Yes, yeah.
I testified the last time I was here that Mr. Ninel's version is that actually the idea of the suspension of the executives was his.
Yes, you said that, yeah.
It was not the president's or Ms. Dudu Mieni.
Yes.
Ms. Liene says, once I was appraised about the purpose of the investigation, I think that was a meeting of the 6th at the presidential guest house, the meeting before the 8th. I then suggested to Ms. Mieni that you cannot do this investigation or this type of investigation and still have the executives in their jobs. That was the version of Mr. Linnell. He then says we met at
The Durban official residence
At the
of
Durban's-
the president.
yes, and they then discussed the areas of investigation with a clear understanding that the responsible executives of those areas would then be suspended. And then he then says, after the meeting, because none of the people in those meetings knew ESCOM. That's his version. So Mr. Tsotsi is the one who emailed him the names of the people to be suspended. And my name was one of the three. My submission to you was that the reasons put forward by Mr. Tsotsi to include commercial and use the gas, the OCGTs, conversion of OGTs from base load, from peaking to base load, based on the letter written by a certain Mr. Jabu Masanganye, the sabotage letter that forced commercial to be included, and pretending that I am responsible for generation when I'm not, was the work of Mr. Tsotsi, and he knew why he was doing it. He was hitting two stones with one stone. He was opportunistically taking advantage of the situation that he did not create, but he found himself into it.
Well, two things. As I understand the position, that you would be suspended. You were one of the executive to be suspended.
One of the three.
One of three, yes.
One of three, yes.
To be suspended. On my understanding of Mr. Linnell's evidence, was already contemplated initially.
On the 6th.
Even, yeah, maybe on the 6th, I might not be sure, but certainly at the start of the discussion on suspensions at the meeting of the 8th. Your portfolio was one of the three mentioned. Now, for me, the importance of that in relation to your suggestion that Mr. Tsotsi was behind your inclusion among those to be suspended is that even before Mr. Tsotsi could say anything, it would appear that you were one of the three that were contemplated to be suspended. And if that is factually true, what does it do to your suggestion that you only got included among the executives to be suspended because Mr. Tsotsi was pursuing his agenda about you?
Chairman, let's take the affidavit of Mr. Nick Linnell further. The affidavit of Nick Linnell says Mr. Koko was going to be suspended because he slept with somebody under the garage or under the parking lot. And Mr. Marokan is to be suspended because he erased the recordings.
Yeah.
And Mr. Matuna is to be suspended because he protected both of them. No one outside ESCOM would create such a story other than Mr. Tsotsi.
Now,
And that is the evidence of Mr. Nel.
yes, now, I don't remember whether to the extent that Mr. Linnell says that, he says that in relation to the meeting of the 8th, or he says that in relation to the discussions at the board on the 11th.
Mr. Nel goes further, Chair.
Yes, but what I'm telling you that I remember quite well, because I saw it recently in his evidence, Mr. Linnell, is that he says Mr. Tsotsi's initial position on suspensions at the meeting of the 8th was to oppose the suspensions. And we know that he says that the suspensions that they were talking about related to 3 portfolios, which included your portfolio. So I'm saying to you, at least at that point, maybe later that might be different, at that point, if that evidence of Mr. Linnell is correct, Mr. Tsotsi doesn't appear to act in a manner that shows some vendetta against you. He's opposed even to your own suspension at that time. Maybe later on it changes, but at that time, I just want I want to see what you have to say about the proposition that if Mr. Linnell's evidence is correct, that initially at the meeting of the 8th of March, Mr. Tsotsi was opposed to the suspension of the executives, that at that stage at least he might not have had an agenda to have you suspended.
Chairman, the difficulty I have with that evidence is that I'm saying to you, the Malisela Sekasimbe, Mr. Sekasimbe, is central to my reason of suspension. And guess what? The reasons for the suspension by Mr. Linnell has that. I have no contact with Mr. Linnell. I have no contact with the people who were in that meeting. But why do we have the same view about Malisela Sekasimbe? Mr. Koko must be suspended because he wants Mr. Koko must be suspended, and I'm trying to quote it now, because he's causing bad blood between the board and Mr. Stotsi because of the Sumotomo matter and Malisela matter. Where would that come from? It's written by Mr. Linnell. And by the way, Mr. Linnell says at no stage did the Guptas get involved into the suspensions. But where did Mr. Linnell get the story of Mr. Sekasimbe? He can only get it from Mr. Tsotsi.
You see, it may well be that at a certain stage, and we can look at what stage that may have been, it may well be that at a certain stage, Mr. Tsotsi did give Mr. Linnell that information. And it may well be that Mr. Tsotsi at a certain stage did adopt the attitude that after all, it would not be a bad thing for you to be suspended because of the reasons that you give. But what I'm saying to you, and we will stop here because I think I've put it to you, you have said what you have to say, is it would seem that at least initially, when Mr. Tsotsi heard about the suspensions, he may not have at that stage wanted you to be suspended. Maybe later on he changed his mind. What's your final comment on that?
Chairman, I agree on one thing, that Mr. Tsotsi did not it was not Mr. Tsotsi's idea to suspend all the executives, because we now know it's an idea of Mr. Linnell. 1. 2, I would buy into your story if the reasons later that were put forward by Mr. Linnell of my suspensions did not include Mr. Sikasimba. The fact that it includes Mr. Sikasimba, whether it came later or not, makes me firmly convinced that Mr. Tsotsi either, and it's possible that he may, first I concede that he did not come to suspend people there, because that is the work, that is the, Mr. Linnell says it's my idea. But I'm saying, given how Mr. Tsotsi felt about me, he used that opportunity to throw my name into the head. That is why down the line, the reasons for my suspension included Mr. Sikasimbe. But there's something more than that really I need you to consider. If I was part of the plan to suspend the 4 executives so that I can come back, why would I be accused of sabotage? Because once I play for your team and you accuse me of sabotage, you write me off. 1. 2, when I addressed the meeting of the board of the people and governments in the evening that suspended me, and I pushed back on why I should not be suspended and gave reasons, because allegedly we're playing for the same team, the board would have used that opportunity to say, but leave this guy, let him come back, because he's part of us, and he's giving us a reason to bring him back, and they would have bring him back. But thirdly, if I am part of the team, and you employ Dentons to come and investigate me, and Dentons come up with allegedly damning allegations against me, but I'm part of your team, surely, if Denton, according to the version that Mr. Silika always put, was part of the scheme, Denton is part of the scheme that they brought in to just go through emotions and clear, they would have said to Denton, this guy is our man. You can't have findings about our man that will make it impossible for us to bring him back. In fact, to the contrary, you must clean him up. But we know, based on the version of Ms. Daniels, however true it is, I think she's a lie, she lies. But if we carry on with her version, they came with recommendations that were so damning that the board had to take the reports and tear it and hide it. It just doesn't make sense.
Well, of course, if the version is true that Dentons came with damning findings against you, for example, and that draft was buried, as it were, one would say that could only happen if the board was part of the whole plan and the board did not want to have something that would force them to fire you, isn't it?
No. Chair, my weakness is that I'm an engineer. That's a weakness. Mm-hmm. In today's time, first, go and check the transcript of Mr. Daniels. He says the document was sent to me by email. So you can trace it.
Yeah.
So I mean, we don't need to, and this is why, Chair, I'm aggrieved that we can't get telephone records. I mean, if I say Mr. Koko was at Melrose Arch and he met Salim, we should do that. So
you will get telephone records that...
I apologize for going back there. I sincerely
yeah.
apologize.
But also, other checking of those things.
I'm simply saying, Chair,
Yeah.
all what you need is what, they've done it to me, Chair.
Yeah.
I know how they've undressed me.
Yeah.
I'm the single person in ESCOM whose IT information has been checked left and center. And I'm simply saying,
Yeah.
if this report was sent by email,
Yeah.
why don't they just do what was, to others, what was due to go in?
Yes.
But finally.
No, that must be checked, that must be
Denton
checked.
says finally, Denton says, we've never done that.
Yeah. Let me go back to what you said about Mr. Linnell. You said that he testified that the idea of suspensions came from him. And I think last time you said the same thing, and Mr. Selega seems to have agreed with you.
Correct.
Now, I just want to say, in the parts that I recently looked at of the transcript of his evidence, what I came across is not evidence where he says that. But what I came across is where he says, and he's asked the question, and I may have been the person who asked him, is he says, as far as this meeting of the 6th of March, his meeting with Ms. Myeni is concerned, he says he is not sure whether the issue of suspensions came from Ms. Myeni or from him. But what he does say is, because of the way he works, it may have come from him, because he wouldn't do this kind of investigation while the executives remain. So I'm just mentioning that because it's important that if we attribute evidence to him, we try as far as possible that we do so accurately. It may well be that later on, and it's a part that I've not reached of his evidence, it may well be that he's as categorical as both of you say he was. So if that is so, I would like to get to that point.
Chair, let me tell you what I
Yeah.
remember him saying. I don't remember him saying suspend the executives. In fact, I don't think he said that.
Yes.
I don't think he said that. What I remember him saying is that in his experience of doing such work, this type of inquiry, when it's done, cannot be done with the head of the department in place. That's what he's done.
Okay, no. To the extent that that's what you say, that's consistent with what I have read as well. Okay.
Chair, I think I've clarified it.
Yeah,
Yes.
okay, no, that's fine.
Yes. So,
Mr. Selega, are you amending your own recollection or not?
no, I was agreeing with Mr. Koko insofar as he has now clarified it, Chair.
Yes,
Insofar
yes.
as it's consistent with your
Yeah.
explanation now.
Yeah.
That's exactly what Mr. Linnell says. So I think that's
Yeah.
correct. I know
Okay.
Mr. Koko might have paraphrased.
Yeah,
So,
no,
but
that's.
now he's clarified.
Yeah, no, that's, the difference is quite important.
Correct.
Yeah.
It is.
Yeah. Okay.
No, it
All
definitely
right.
is.
You may continue.
Yes. The other thing, Mr. Koko, which I don't remember, is that Mr. Linnell would have mentioned that one of the reasons crafted for your suspension had to do with Sumitomo.
Chair, there's 8 memo.
Yeah. I'm saying I don't remember that, so
Chair, there's an 8 memo. Now, Chairman, remember, I'm the affected party. I will never
Pay
forget.
more attention.
I pay more attention.
Yeah,
Go and read the 8 memo. It's clear, black and white.
yeah, okay.
I will also check. As you can see, I'm doing in regard to these other ones.
Yeah.
Yeah. Chair, there was just one thing. I know we will come back to the emails in due course, but you were explaining something that I couldn't get clearly. So the email address of InfoPortal, you say it's given to you by Ms. Daniels.
That's correct, Chair.
So when you send the emails like this, like print this, there's no dear so-and-so or hi, Suzanne or Dr. Ngubani, who do you say you're communicating with?
Chair, on that score, I knew that the recipient on that specific topic would have been Suzanne. So I'm saying, print this bring it to the meeting with the chair.
Yeah, but it doesn't have that last part.
Which part?
Bring it to the attention of the chair.
No, I am explaining, I'm giving you the context. Context is everything. Print this what? Print this for what?
Okay, let's just get that right. Are you saying when you sent emails to this email address, you were, as far as you were concerned, communicating with Dr. Ngubane?
Correct.
And Ms. Daniels might just be the conduit in the sense that she might open the emails and then print it and give it to Dr. Ngubane.
Correct.
But you are saying from your side, the addressee, even though you might not have identified him, was
Correct.
Dr. Ngubane. Okay.
Okay. So all of them, all of these emails, yeah. And I'm trying to understand this. All of these emails are sent to Dr. Ngubane,
Correct.
but they will be opened by Ms. Daniels.
Correct. In fact, the chairman had two executives who executive assistants. But on this email, by and large, without fail, that was Suzanne.
Yes.
Okay.
Now, on that note, if you go to page 1087, ESCOM bundle 18.
Yes.
I'm sorry, before you do, you go there, Ms. Daniels would not have been Dr. Ngubane's PA. They would have been a PA for Dr. Ngubane, is that correct?
Yes, so what happens is that up to a certain stage, and I don't want to mention the date, but it was, I suspect, if I recall, around August, she was promoted to the company secretary.
Yeah, okay. And then being company secretary, did that place her in the chairperson's office or not necessarily?
It placed her at the chairperson's office.
Oh, okay, all right.
Yeah.
Mr. Seleng.
Yes, I was saying on that explanation, Mr. Koko, if you go to page 1087, 1087 ESCOM bundle 18,
That's
we
right.
see, you're there? You're there? 1087? No. 1087 ESCOM bundle 18.
1090.
The black numbers.
Yeah.
The black numbers.
The black
Apologize. Yes.
The email of the 10th of December
Yes.
comes from businessmen.
Yes.
It goes to you.
Yes.
You forward that email
Yes.
to Suzanne Daniels.
Yes.
So how should we understand this?
Right. So if you look at the timing, it's 7:31. If you go to my telephone records, I've not given you my telephone records for December. I'm happy to give them to you. You will see. You will
what?
see.
You may give them?
I'm saying I've not given you my telephone records of December,
Yes.
but I'm happy to give them to you
You're happy to give them to, okay.
based on what I'm going to make.
Yes.
Around 5 minutes before this, I phoned Suzanne.
Yes.
And she also said, when you confronted her with this, she says, she thinks I called her.
She said what?
I'm sorry.
She thinks I called her.
You called her.
Yeah, that's what she says.
Okay, but I've missed something. Just go back to the beginning of your answer.
Oh, I'm saying if you look at the timing,
Yeah,
It's
7:31.
7:31 in the morning. About 25 past, 5 minutes before this, around 25 past, I phoned Suzanne. I said, Suzanne, I have received an email that comes from the chairman. It relates to the prepayment. I am forwarding it to you because you are dealing with the prepayment. I have not looked at it in details. Look at it in detail and advise me on how to proceed because I know you are dealing with it. I forwarded it back to the email of the chairman where it comes to the normal email. Please discuss it with the chairman. because I don't understand what is it all about. And Chair, I must tell you, I not read it in details, but when I looked at it, it's a prepayment. It's what Suzanne is dealing with it. I sent it back to her. Say, Suzanne, please discuss with the chairman what she sent me, because I don't understand what is it, what the detail of it, you know better. And the reason I did not understand is because I took the transaction up to the approval stage. The giving effect of it was with Anosh and Mr. Singh. So that's the only reason why this was sent to Suzanne.
Yes, but the email is not about the prepayment, it's about the guarantee.
That's what I'm talking about.
And the chairperson was here who testified. They knew nothing about this guarantee. It was something they came to learn, that it was done by Mr. Anoj Singh, and it didn't even come to the board. As far as they knew, they had made a resolution for a prepayment on the 9th of December, the day before this email is exchanged.
And I understand why the chairman will say that. I understand why the chairman will say that perfectly. And the reason I understand why the chairman will say that perfectly is because I put together a submission to the board. And my affidavit tells you that I also did not know about the guarantee. So I'm not surprised that the chairman does not know about the guarantee. I was the recipient of this email, but I still don't know about the guarantee.
Well, from my point of view, it seems awkward that the chairman would send you an email dealing with these types of issues that are mentioned here, simply because I think that these would be matters that would be dealt with by the executives and the potential suppliers or suppliers, and then the board would be briefed at particular intervals. But this email seems to be of somebody who is very involved in the actual contracts or terms of the contract.
I agree with you. I agree with you, Chairman.
So, but then the question that arises in my mind is why this wouldn't have made you say, but the chairman can't be talking about this thing. What's going on? Who is this businessman? Because the chairman can't be talking.
Chairman,
about
I
this
knew who's the businessman.
Yes.
It was the chairman.
Yes, but that's the point. Namely, how can the chairman be talking about these things? In other words, you begin to say, but why? Maybe you would seek an explanation, because it's not the type of issues that you would expect the chairperson to be involved in.
Chairman, now your reasoning makes sense. But I did not have that reason. I did not have the reason to do that at that point in time. I did not. And that is why I sent it to Suzanne. I says, come back to me. Let me know. In fact, later in the afternoon, we met for lunch. And I asked her, did you receive the chairman's email? He says, yes. Is there anything I should worry about? Should I be worried about anything? He says, no, don't worry, I'm handling it. And let me tell you, my fault, if any, in many of these transactions is probably because I trusted too much. That's my fault. I think I should probably have said, but Suzanne, are you sure this is the chairman? I did not do it. And if I'm guilty, maybe I'm guilty of that.
So you gave the email. This is the email you gave to Ms. Daniels.
Correct.
Yeah. And you say you had not read it.
No,
Yes, you had a glance.
I had a glance of it,
Yeah.
and for me, it was very clear that it has to do with the transaction that I started,
Yeah.
that I have delegated to Suzanne
Yes.
to finish off, that the board resolved that Mr. Singh must finalize. So I said to Suzanne, the transaction that I've asked you to conclude, this email relates to it, and it comes from the chair. So I can't ignore an email from the chair. I can't. Others I ignore. Others, but this one I can't. Please look at it, action it. Let me know if we should go and see the chairman. And when I met her later in the canteen, she says, "Are you actioning?" And he says, "It's fine, don't worry about it." And I left it at that.
Is that where it ended, or the whole thing was pursued later in terms of these items?
Well, that's where it ended. But I've later now, having listened to the evidence of Mr. Seleka, that the whole paragraph was inserted verbatim in the guarantee agreement. But that I only know now.
Mr. Seleka?
Yes. Yes, Chair. You see, Mr. Koko, the way I recall Ms. Daniels' testimony in regard to her not being able to recall whether or not you called her, it was about the next step that she took. Because I was asking her, when you forwarded this email to her, what were you expecting her to do with it? What did you tell her to do with it? What was her recollection? And she couldn't recall whether or not you telephoned her. But the next step was that this very the contents of this very email, as you have pointed out to the chairperson, they find their way into an email that went to CDH for instructions for them to draft an agreement. And it is, as I recall, on that day. They drafted the underlying agreement and they sent it back, which, on the face of it, it suggests that that was the instruction that she had received from you to instruct CDH to prepare that document for the purposes of pursuing the guarantee.
But that's not her version, Chair.
2, it's precisely strange that you started a process that deals with a prepayment, cash prepayment. You have a board decide on the 9th, because you started this thing on the 8th, maybe a little bit before that, but the submission is dated the 8th. The board makes a decision on the 9th. You get this email that now talks about the guarantee of the same amount that was in your submission, 1.68 billion. That's why the chairperson is asking. But wouldn't you say this is strange? The chairman of the board was part of the decision-making for a prepayment for cash. Why is he sending me an email about a guarantee? Is this the chairman?
Yeah. Chair, 2 things. I will testify here that there is absolutely nothing wrong with the transaction of the 1.6 prepayment. In fact, it was only alternative available to ESCOM. Now, Chair, I've listened to the testimony of Mr. Ntata, and I'm glad I have the privilege to be here.
Chair, if I may, because I will come back to that issue whether or
I
not
want to,
it's-
okay, let me answer it directly.
Yes.
Okay, let me answer it directly. At that point, saw absolutely nothing wrong. In fact, the prepayment was very topical on the day. So when I received the email, for me, in that floor, everybody should be talking about this because it was the single most important thing happening at ESCOM on that day. If anybody was focusing on something else, then he should not have been at ESCOM.
But it will be those who know about it.
I beg your pardon?
It will be those who know about it who talk about it.
Chair, if anybody at ESCOM was not focusing on this problem on that day, then he should have not have been at ESCOM. The 1.6, the prepayment at ESCOM on that day, on that week, was the single most important part. And that is why I want to say to you, you must judge me going forward. You must judge me on ESCOM memorandum of incorporation. You must judge me on ESCOM delegations of authority. You must judge me on the compliance of ESCOM directive. You must judge me on ESCOM compliance, on my compliance with ESCOM procedures. And most of all, having complied with that, you must judge me on whether my decisions have been prudent or not. Not whether somebody said this or that.
Yes.
So I have no issue. When I received the email from the chairman dealing with a topic that I thought is very important, and I immediately reacted to it and sent it to Suzanne and said, please look at this. It relates to that important topic I've sent you. If you need us to go and see the chairman, let me know.
Yes. Well, I wanted to say other people at ESCOM, there would have been other people at ESCOM who have no role to play in the prepayment, and therefore they would legitimately not have to talk about.
Most certainly, Chair. Most certainly. I'm just sending the message across. Chairman.
No.
You see,
We don't have to take it further. I know that you didn't mean it literally.
Yeah, you've had two weaknesses here, Chairman. You've had two weaknesses here. You've had witnesses who say it's fashionable to disown the right things that we've done so that we can be liked by the CJ, Chief Deputy Chief Judges, and by relevant people out there. So we had a lot of weaknesses. I mean, I sit here, listen to Suzanne, trying to disown the right thing, and she looks stupid because she's trying to disown the correct thing. I will make a submission here to you, Chair, that every single signature on the document before you, even though the document was prepared by somebody else, I own the decision. It's my decision. I'm never going to disown my decision. I'm never going to say, I signed this because Mr. Molefe said this.
Yeah, no, it's very important, Mr. Koko, that all of us stand by what we believe to be true and the right thing. So, and not move or change if you have made a decision you believe is correct, you stand by that decision. The fact that somebody else might think you were wrong is neither here nor there, but from your side, if you think the decision was right and you still think it was right, you stand by it. Of course, if having reflected or having heard what other people say about the decision, you think you may have been wrong, it's also a good thing to say, at that time I thought it was right, but I've listened to what so and so has said, and I'm able to say, I think I may have been wrong, I think he may be right, she may be right. So in the end,
Most certainly.
yeah, that's the right thing to do, but not to say something is wrong when it is right, or it's right when it is wrong. I see we've just gone past 6:30.
I just saw that as well, Chairperson.
Yes.
And
Did you have one or two questions to finalize, or should we just adjourn now?
let me tidy up
Yeah, okay.
the last
Okay.
testimonies. Then, when we come back the next time, we could go straight into the transactions. I have just two more Mr. Koko. There's another one, but I haven't given you the bundle, so I'll ask you when you have that bundle. The other one is this, that your version both in the affidavit and orally, and I see it's repeated in the letter, Chair, which I have handed up to you, the letter dated the 3rd, is that Mr. Matona telephoned you over the weekend prior to your suspension. And he would have spoken with you again about the Sumitomo matter. Chairperson, on that letter that I handed up, that's paragraph 20 of that letter. I'll just read it up. That's the letter from Mr. Koko Satenis. Paragraph 20 says, Mr. Koko avers that he had a telephone conversation with Mr. Matona on Sunday, 8 March 2015, during which Mr. Matona informed him that he had been instructed by Mr. Tsoti that Mr. Sikasimbi had to be unsuspended. Now, I have noticed that this version is not the same as you gave the Parliamentary Portfolio Committee. Do you remember that?
Chair, no, I gave the same, I gave the same version.
You gave the same version. Okay. Well, because you are a man of remarkable memory, bundle 15B.
Can I put this away?
15B, just push it to the side.
Well, I just want to say something in with respect to what is written in paragraph 20 of the letter.
Yes, Chair.
Namely, it would be a straightforward matter for the Commission's investigators to establish whether a telephone conversation, as Mr. Koko alleges, took place on 8 March 2015. One, I don't know whether the investigators have checked that and what they found, if they did, but I do know that I have been told that telephone records, I think for some of the service providers, whether it's Vodacom or MTN or whatever, I'm not sure, don't keep records beyond 3 years or beyond 5 years now. But I know that what I've been told is that where, for example, the public protector had obtained certain records during her investigation, certain records, those are available. So I'm just mentioning to you what I've been told.
But Chair, I gave the Commission my telephone records. I have nothing to hide. 12 minutes, 12.3 minutes
Yeah,
on the 8th.
yeah,
That was how long the discussion Mr. Matona and I
Yes.
had on the 8th.
yes. No, what I'm saying is, your attorneys say in that paragraph, it would be an easy thing for the Commission to obtain the records of the telephone conversation on the 8th of March.
But I've done it for you and I've given it to you.
Well, if you have given us that, that's fine, but I'm just saying,
Yeah.
from what I've been told, it might not be so easy if you are talking about something that happened more than 3 years ago
Chairman,
or 5 years ago.
I have nothing to hide. I may have made a mistake or two. That is why I give you my telephone records.
Yeah.
I said Mr. Matuna called me. I called Mr. Matuna
Yeah,
on the 7th and on the 8th.
yeah,
I've highlighted those calls on my telephone records.
Yes.
And I've given them to you.
yeah. I
We
haven't
will,
seen them, but I take it that the legal team has got them.
yeah,
And Chair, it's 2015, so I could not have anticipated this.
Yes,
yeah.
yes.
Chair, I believe we have been given some documentation this morning. I haven't looked at it,
Yeah, okay, all right.
but here it is. Chairperson, I gave the page number, 15B. page 1082. ESCOM bundle 15.
Do I need to look at it or
Yes,
you?
I think it's
Okay.
important.
Okay.
It's very important. This is, Mr. Koko, this will be the transcript of your testimony at the Parliamentary Portfolio Committee.
B, I've got 18B. What page?
15B.
15B.
Yes,
1, 5, yeah, this is 15
that's the
page.
one, yes.
And
Page
what
10,
is the page?
1082.
1082.
Correct, Chair.
Yes.
Yes. So this is a transcript from the Parliamentary Portfolio Committee. It starts on page 1047, but I just want to deal with the point here under consideration. At the bottom of the page, I think Mr. Koko here was being asked questions by Dr. Luyenge. And the question was, you allege that, or have an assumption or a belief that Mr. Tsotsi suspended you for a reason that you know. What do you think the reason behind that suspension is, if it was unjustifiable by Mr. Tsotsi? Then shall leave all that. Mr. Koko has given an answer there, but let's go to the last, from the bottom, 1, 2, 3, 4, where he starts with the CEO. From the bottom, 1, 2, 3, 4, the fourth line. The CEO of ESCOM came to me and said, Mr. Koko, you are making a problem for me because I have an instruction from the chairman that you must suspend Mr. Sekasimbi. Now you will see, you say he came to me. Or both of us are going to be suspended. I said, but Chief, I have kept you in the loop. You know why I did what I did. I will not do it. You say that was on Thursday. I mean, Mr. Matuna himself has confirmed that he met with you in the office where you showed him that letter signed by Mr. Tsotsi. So you say that was on Thursday. But here's the part. On Sunday, I got a call from the chief executive's assistant. Who's the chief executive? Is it still Mr. Matuna?
No. The assistant of the chief executive
No. Who's the chief executive?
is Mr. Matuna.
That's Mr. Matuna.
Yes.
Okay, who is his assistant? Who was his assistant?
Mr. Ndo.
Ndo.
Yes.
So on Sunday, I got a call from the chief executive's assistant, so I'll say Mr. Ndo. He said, what's happening? I believe that there is an urgent board meeting on Monday to suspend you and the chief. I said, I don't know, but I heard something similar from the chief. On Monday, I walked into the office. I went to the chief. The PA said that the chief was not there, but he was at the board meeting. Mr. Koko, I think it is about you and the chief. I left the office, and that was when I called Ms. Daniels. We were not suspended on Monday. So there is different from what you're saying here in your letter. The letter repeats your version in the affidavits, the version that you have said all along, at least here before us, that it was Mr. Matuna who called you on Sunday, 8 March 2015. But you told the Parliamentary Portfolio Committee that, under oath, by the way, that it was the chief's assistant.
No. Chair, my affidavit is very clear. And you may want to nitpick that I use the wrong terminologies or whatever. I think Mr. Seleka is trying to make an honest error of memory on my part to suggest that a credibility issue is wrong. Is completely wrong. When I say, there's two issues here that I think is trying to bring to our attention. Mr. Matuna came to me, so you can't come to you on the telephone. That's what he's trying to say. So he did not come to me. In fact, the telephone record shows that I called. I made the call. I don't remember on my telephone records. I can only see the calls that I made. I can't see the telecom records that I have received. I remember very well having a discussion with the assistant of the CE, Mr. Ndou. I remember very well. I mean, I know how he speaks. Chief, what's going on? So that happened. So I think, and it's up to you to make the decision, but I
Yes.
think Mr. Seleka is making a mountain out of nothing.
Yes,
Mayor.
let me say, Mr. Seleka, and you can then
Okay.
deal with it or address it. I thought that the evidence that Mr. Koko received a call from the CE's assistant may not necessarily have meant that he didn't have a telephone conversation with the chief executive, Mr. Koko, because he says here, when speaking to the assistant, I don't know, but I heard something similar from the chief, which may suggest that he had spoken to the chief executive, and the chief executive had already told him the same thing. But whether that discussion was on Sunday the 8th or earlier might be another issue.
Well, I've been talking to the chief from the 7th.
Yes.
Telephone records will show extensively.
Yes, yes. So I think, but to the extent that Mr. Koko has provided telephone records that show that he had a telephone conversation with Mr. Matona on the 8th. I'm not sure whether if he has provided that, you would be able to take the point any further, at least until you have heard what Mr. Matona has to say about that.
My disappointment, Chair, is that Mr. Matona denies it. That's the only disappointment.
Yes.
But
Well,
it's- but it's there and it's factual.
But he has not, I assume, he has not been shown your telephone records. So it may well be that
Yeah.
when he is shown, because he should be shown,
No, of course it should be shown, Chair.
yes,
But-
that we would like to hear what he has to say about
Correct,
that.
correct, Chair.
Yeah.
We will also have a look at the telephone records.
Yeah.
But what I'm doing, Chair, because I see Mr. Koko imputes a particular idea on me or view. All I've done is to read what he testified. He came to me, he said that was on Thursday. And then he goes on to say, on Saturday, I was called by the chief executive's assistant. And he doesn't say the chief executive also called me on Saturday, but he says, on Monday, I went to his office. And the PA said, he's not there, he's in a meeting, I believe it's about you.
But I also say I heard from the CE.
I'm sorry,
Yes,
but yes, you see,
And I will-
you have to explore first what he was talking about when he said, I had something similar from the chief.
Yes, and similar, Chair, because-
But if, for example, whatever the position is, if he has provided proof that there was a telephone conversation between himself and Mr. Matona on the 8th, I'm not sure that you can take this forward until you have heard fully from Mr. Matona about
Of course, Chair. No, of course.
yeah.
Of course, I was just saying to him, this is how he testified.
Yeah, because
and-
Mr. Matona might say, oh, then maybe we did have the conversation and take it from there. You know. So, but it's important that that be investigated.
Correct, Chair. I agree.
No, I think we should.
I think we should
I think we should adjourn.
Yes.
Yeah. We are going to have to, we'll have to try and make sure that the date, excuse me, the date that I will fix be a clear day for Mr. Koko.
Yes.
So that we can try and finalize his evidence. We will, I'll try and determine a date quite soon.
We appreciate that, Chair, because the prior dates of the meetings were not canvassed with us at all, despite the fact that we at all times made it very, very clear that we will do our best in all circumstances to be where we are requested to do. But nevertheless, simply notices were issued to Mr. Koko without any prior consultation. We're heading into the court term. It makes life difficult. So we would appreciate that courtesy. Obviously, at some stage or another, there's got to be a date, and the final decision lies with you and my learned friend. But we do appreciate what you have put on record. Thank you, sir.
No, my plan is that I'll allocate a full day for Mr. Koko so that as far as possible, he can complete his evidence. Thank you to all of you for all your cooperation, that we have been able to have an evening session. Okay, and my registrar, please arrange for that meeting that I said I would like to have, communicate with Mr. Selega, the secretary, and Mr. Selega will tell you who the other people should be that should be brought into that meeting, coordinate and make all arrangements. I would like to have that meeting before the end of this week. Okay. Thank you very much. We are going to adjourn. We adjourn.
Thank you, Chair.
All rise.
Are those the only